period. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you very much, and good morning. I'm going to begin by introducing the panel to everybody here. You can stand there. It's okay. Don't worry. To my right is Justice Kenneth Desmond. To my left is Justice Robert Toone. My name is Ariane Vuono. We have a full day today, 6 cases scheduled to be argued. We will probably take a short break after case number 4. If that changes, we'll let you know. Just want to remind everybody that we've read everything that you've submitted to us, and 15 minutes can seem like a long time, but you should get right to your most salient points. And if you don't need your entire time, that's not necessary to use it either. And lastly, there is no rebuttal in the appeals court in Massachusetts. So the first case, I see we're ready to go, is number 2024-0608, Ellie PARISEAU, did I pronounce that correctly?
PARISEAU.
PARISEAU, okay, versus Commonwealth of Massachusetts. Counselor?
Thank you very much. Rachel Chana on behalf of the appellant, Eli PARISEAU. I'd like to begin by addressing the content of the government's 16L submission regarding the specter of mootness in this case. First of all, this case is not moot. When continuing interests are at stake, appeals from expired commitment orders or medical treatment orders are not moot and should be reviewed on their merits by this court, especially where they raise issues of public importance that are capable of repetition yet evading review due to the length of the appellate process, which is the case here. We see that in the documents submitted by the government. In the docket appended to the 16L letter, we see that last month, at last month's trial, certain issues recurred. Namely, the government moved to exclude reference to SORB classification. The government moved to admit risk category labels, and Mr. PARISEAU moved to exclude evidence of alleged crimes not resulting in convictions. So presumably, I could, if this court were to moot out the appeal, I could be appointed to represent Mr. PARISEAU again when the case is transcribed several months later. I could submit essentially the same brief. It would probably again be mooted out because Mr. PARISEAU is already scheduled for his next Section 9 trial in November 2nd of 2026. These issues keep recurring. Additionally, this court...
What was the result earlier in September?
I can't hear you, I apologize.
What was the result of his trial earlier? He had a redetermination hearing?
He was again committed by a jury.
Okay.
In September. This court can still give Mr. PARISEAU the relief that he is seeking.
Was he classified again?
Excuse me?
Was he classified as a level 1, 2, or 3 at that time?
Mr. PARISEAU is pre-classified as a level 3 and is certainly going to be a level 3 upon his discharge, if he is ever discharged before his death. It is all but certain. And so the relief that Mr. PARISEAU is, I'm sorry, I hear some echo. Is that?
They're
Okay. The relief that Mr. PARISEAU is seeking through this appeal is not, and at no point has been, discharged from civil commitment, because if he wins on the merit of this appeal, what he wins is a new trial, which he is statutorily entitled to anyway. So what he wins is far more substantive. What he wins is this court setting the legal parameters of his next trial, because right now we don't have that. We have Rule 23 after 128, assuming without deciding important evidentiary issues that recur and recur and recur again. In fact, in every Section 9 case where the petitioner does not have a probation tail, the government is moving to exclude evidence of SORB classification. So this is recurring at every Section 9 trial of a similar class.
I understand your point about not being moved because of an issue reoccurring and evading review. Just to be clear, though, if we were not to be persuaded by that, hypothetically, all right? When you say that your client would still receive a benefit because he would receive a new trial, does that mean he would get yet an extra new trial, so to speak, because the statute, as you say, already automatically gives him the opportunity to file a Section 9 discharge? So would he sort of have another one in the wings, to put it colloquially, or not?
So, I mean, even if, say, like the Rule 23 were already written by one of this court's clerks and came out 2 weeks from now, and Mr. PARISEAU was scheduled for a Section 9 trial, he's already scheduled for one, so that one would occur later, right? So this was more relevant when it was taking 5 years between Section 9 trials.
Right, and now what is the average?
And now they're happening so much quicker.
Okay. All right.
And so what this does is it sets...
So other than those issues that you've pointed out are important ones, he won't receive a benefit. The case would be moot. There's no actual controversy in that respect, right?
Well,
because he's about to have another trial already in a couple of weeks, and still under the statute be entitled to yet another one. So,
right, and that's the case for all Section 9
Correct.
appeals. And yet, Section 9 appeals are brought to this court because there are important evidentiary issues that occur. And so I would refer this court to the matter of FC, explaining why in the analog statute, Chapter 123, appeals from expired civil commitment orders in that other mental health context are not moot, because the same issues were recurring and recurring and recurring, and the petitioners would be committed under a second and subsequent civil commitment petition by the time their cases were heard by this court.
Okay, so you say that the same issues will be recurring over and over again. So when you say that, are you pointing to the terminology that they used for the static 99 with respect to high risk, moderate risk, or the newer terms that they're using now? Is that one of the things you're pointing to?
So as I mentioned...
That calls for a yes or no. So is that one of the things that you're pointing to, or no?
I don't think Your Honor accurately phrased that.
Okay.
In part, yes, but yes with a qualifier, because it's not just the terminology, it's a contested pseudoscientific interpretation of data that is contested, not merely terminology, these so-called risk category labels. And yes, we know that issue occurred again at Mr. PARISEAU's September 2025 trial, and we know it will, unless decided by this court, will occur again in November of 2026.
And what about
also, the issue...
What about the closing argument?
I have not read the transcript. I have no reason to doubt the government's representation that he has stopped making that argument after this court in De Amicus concluded that it was certainly error.
And did they take FAR on a case that was very similar to the case that we have here today, De Amicus? Is that the case? Did they seek FAR?
I don't have that information, Your Honor.
So you wouldn't know. I mean, FAR was denied. Should we take anything from that, or you're not familiar with?
No, because I mean, it's impossible to take anything from a case with no precedential weight or value. It's merely a Rule 23. I don't know the facts of that case. I don't know anything about that case.
Okay, so your strongest argument with respect to this appeal is what?
I'd like to start with the issue of the uncharged misconduct that was admitted erroneously against Mr. PARISEAU. So fundamentally, hearsay that's inadmissible under the rules of evidence is inadmissible under a Chapter 123A proceeding unless the evidence is specifically made admissible by statute. Here we're talking about Section 14C that enumerates certain categories of evidence that are made admissible, specifically police reports relating to such persons' prior sexual offenses. But here, we're not talking about offenses. Marquardt is was clear on that. Nor are we talking about contemporaneous conduct like Given, nor are we talking about a specific pattern of conduct occurring within hours like Starkus. In fact, we're not even talking about a police report. I want to be very clear about that. Something that fundamentally distinguishes this case from Given and Starkus is that we are not talking about a police report. The Commonwealth was not seeking to introduce a police report. What they were seeking to introduce was 4-layer totem pole hearsay. It was Peretti and Robertson who read a 2017 report that stated that police in 1984 heard statements from 2 unnamed, unidentified declarants who claimed that their 6-year-old daughters separately made statements to them, who are also unnamed. Those so-called claims, that 4-level hearsay, was never investigated, let alone resulting in any charges. It is impossible at any time for that to be cross-examined. And what it does, the prejudicial effect of the erroneous admission of this evidence cannot be understated because it doubles.
Is it your position that unless it's charged conduct, it's inadmissible?
No, that's not at all my position because the case law contravenes that position. What I'm saying is that we don't even know that this was in a police report. So this is 4-layer hearsay.
What report was it that we were looking to when they talked about, were you talking about the 2 6-year-old girls, is that right?
Yes.
Okay, what report?
Allegedly, right? And so if you look at the Commonwealth's record citations, what it cites to, other than the trial testimony, is a 2017 CAB report. What was not produced was any document underlying that CAB report, okay? So we have 4-layer hearsay. This is markedly different from when the government seeks to introduce a police report. And the prejudicial effect cannot be understated, where the erroneous admission of this evidence doubles the number of victims against whom Mr. PARISEAU allegedly had contact offenses against. So in that context, where the government erroneously doubles his number of victims, we can't say that this didn't have an effect on the jury or had but a slight effect. This is all the much more so the case in the context of Boucher, in the context of these instructions, which the judge properly instructed the jury that in Chapter 123A proceedings, the jury is empowered to define an essential element of the government's case and then define the quantum of proof necessary to meet that element, namely whether Mr. PARISEAU was likely to commit sexual misconduct if released. The jury is empowered to define what likely means and at what point, at what risk it becomes likely. And so in this context, and then what the jury hears from the government is that no risk is an acceptable level of risk, right? Like you're no longer thinking about the 12% risk. You're thinking about each juror's personal willingness to risk their own death by poison. That's what the jury hears from the government's lawyer in closing argument. When the jury is empowered to define likely and then define what quantum of risk is too much for them, they are left thinking about their own willingness to accept death by poison, while Mr. PARISEAU's liberty interest is trivialized to the status of a cookie. That is the error in this case, and that is the error that needs to be corrected before Mr. PARISEAU's November 2nd, 2026 trial.
Okay.
Mr. PARISEAU will remain pre-classified as a level 3 sex offender at his November 2nd, 2026 trial. I'd like to suggest that the court think about this evidence analogous to a mutina instruction and setting forth the consequences of a verdict, right? The mutina instruction sets forth the consequences of a not guilty by a lack of criminal responsibility verdict to avoid unnecessary speculation by the jury as to what protection their fellow citizens would have if this mentally ill murderer were released into the community. SORB has the same effect. Because the entire purpose of SORB as an agency, as a statute, is to reduce the risk of sexual offending through intensive monitoring and disclosure, and the jury was entitled to hear that evidence. This is, again, an issue that keeps recurring in Section 9, after Section 9, after Section 9, that still has not been decided by this court. And Mr. PARISEAU asks that this court decide these issues on the merits.
Okay. Any further questions? No further questions from the
Thank you.
panel. Thank you very much for your argument.
Good morning, Brian Mansfield. May it please the court for the Commonwealth. As to the mootness issue, this is not the first time this court has been presented with this identical issue. Just 2 years ago in the LaSalle case, which was, I'm sorry, 23P1410. Mr. LaSalle had an active appeal. The briefs were filed.
It's an unpublished decision?
Pardon me?
Is it an unpublished decision?
No, it's actually an order of dismissal.
Oh, okay.
So the case was fully briefed. They came to argument, and right just before argument, similar to this case,
Yeah, I understand the
Mr.
posture.
LaSalle was found sexually dangerous again. And although there were issues, including the issues of the static 99R risk labels, the court found that it was moot and dismissed the case by order, not even by a decision of the court. Again, Mr. PARISEAU was just found sexually dangerous in 2025. There were some of the same issues. As my counsel acknowledged, the closing argument did not contain the analogy that is at issue here. The risk labels were an issue. As far as the Sex Offender Registry Board was concerned, evidence of sex offender registration was before the jury, other than the fact that he had been provisionally classified as a 3, which I'm not sure would help them, help Mr. PARISEAU at all if he heard another independent public agency had found him to be at the highest risk to reoffend if that level 3 had come into evidence. And then the other issue that is similar is the issue of the 2 uncharged offenses. So
What
again,
about the point that the availability of successive trials essentially could just foreclose appellate review of these decisions because there's always another trial coming down the pike, and it takes so much time to sort of prepare a case for appeal? I mean, that would kind of take our role out of the process altogether, wouldn't it?
I think if the issues were of such public importance, which in the LaSalle case they found the issues before them were not of that importance, that you could, with your discretion, continue and decide the appeal on the merits. If I may speak first to the Sex Offender Registry Board issue, again, that evidence was entered in this past trial for Mr. PARISEAU. But as far as the Sex Offender Registry Board, the Supreme Judicial Court has found that there is no evidence that it actually does reduce the incidence of sexual misconduct, and that to say that is pure speculation. Second, the SORB does not supervise sex offenders. It's not like probation. If the individual is subject to probation, that always comes into the trial because there is research that says probation may have some effect on the likelihood of reoffending. So the difference being that probation is actual supervision. Probation can set forth conditions, including requiring sex offender treatment. The Sex Offender Registry Board, other than registering once a year or once a month if the individual's homeless, it's a public notification. It does more to, as the judge in this case discussed during the motions to eliminate, it does more effect on potential community members who may be aware that there's a sex offender living in the neighborhood. It may curtail or may change how they go about protecting their children in that neighborhood, but it certainly has not been shown to have an effect on an individual like Mr. PARISEAU.
But are you saying there's no relationship between registration and the likelihood of an offender's reoffense?
The research is out there is actually the opposite proposition, that because sex offenders often offend under stress, there is research that says when you have a registration and it affects your ability to get a job, or it affects where you can live, or your neighbors know it, that tends to put men into stress. And when they're in that stress, they tend to reoffend sexually. So the only research that's out there has the complete opposite proposition.
Seems kind of I'm not doubting the research, but it seems kind of non-intuitive. And what opens the question is, why do we have this system if it's people are more likely to offend when they're registered, right? I mean, that seems very problematic.
I mean, again, I think it's for the public
notification, right? But
right, and once they know, they can adjust their behavior. But there's no research that shows that it has any effect on the behavior of the sex offender, other than that putting them under stress, which is one of the major precipitants of sexual reoffending.
What research do you point to for that proposition?
I don't have the name of the article right in front of me. Again, that was not an issue in this case because the Sex Offender Registry Board was excluded.
But that particular research, it's also not part of this record, right?
It is not.
Okay, just want to be clear about that. All right.
And as far as his classification, Mr. PARISEAU was provisionally classified, but if he were to be released, they have to have a final classification, and of course he can contend that. And it's just speculation to say that he would be further classified as a level 3. Of course, the Sex Offender Registry Board can do what they will with the information, so there's no guarantee he would continue to be a 3.
He's 71 years old now?
He was 71 at the time of this trial, I believe. I believe he's now 76.
76 now.
As far as the evidence of the 2 girls, that information when the report's quoted, it's coming from the police reports. So during the course of the investigation in 1984, where Mr. PARISEAU was found guilty of, open and gross, he had taken a 3-year-old girl into the bathroom, removed his pants, removed her clothes. When the father heard water running, he tried to get into the bathroom, which Mr. PARISEAU apparently had his leg up against the door. It took some effort to get in. So it was sexually, and when he was found, Mr. PARISEAU had a full erection. So it was sexual aggression against a young child. It's the exact same thing that during the course of the investigation of that offense, it came to light that 2 6-year-old girls had also reported that Mr. PARISEAU had approached them in a sexual manner and, in fact, kissed them in each case. And that was the evidence presented at trial.
Counsel says that reference is in a CAB report, and you're saying that it's in a police report. Specifically, what police report is in?
The police reports were not entered into evidence in this case, but they are recited generally.
Is the police report in the record?
No, it's not.
It's only referred to in the CAB report, am I correct?
Yes.
Okay.
So unfortunately, that happens sometimes is one report will recite the facts from a police report, and then future evaluators will look at that report for the factual base, so it's repeated, but it was in the police report.
Well, how many layers of hearsay in this case did we had to go through to get to these facts? Do you agree there's 4 layers? You count them? Possibly. Okay.
But I mean,
So is there an issue about, I mean, there does seem to be an issue of unfairness when you get to multiple levels of hearsay to get to information that by itself seems relevant. So what are the limits on the distance between
I think when
the
it's
evidence and how it comes in
when it's a
court?
police report, so you get the police report, then you have, in this case, the mother reporting for the two 6-year-old girls.
Yeah, but we didn't get the police report, right? That's what I'm
No,
saying.
It's quoted in at least one of the reports, though. The other thing, this is very much like the Starkus case. In Starkus, he had approached a teenage girl, had a sexual offense against her. In the investigation, they found out that there were other girls who had accused him of similar conduct. And this court had allowed that in because the police report has a level of reliability that in the fact
The issue is the police report. And so I didn't hear an argument saying that it was not admissible if it was contained in a police report. I heard that there is no police report before us, and it's referenced in another report.
the police report's referenced in another, yeah.
But we don't have the police report, so we got to
Have just quotes from the police report.
Exactly. So that's the issue, unlike Starkus, right?
I don't know whether Starkus, whether the police reports, in Starkus, he pled guilty, so whether.
There was an admission to the underlying conduct.
Correct.
Well, you would agree that it's near impossible to conduct a cross-examination about information that's contained in that many layers of
Correct.
hearsay.
Right. And obviously the rules.
Seems to me a problem that occurs all the time. I mean, these CAB reports rely on these prior reports that are, as you indicated, I think you even used the term unfortunate, that unfortunately the information is there and it keeps getting repeated. How do you suggest that that gets changed?
Well, I mean, we have no control, the Department of Correction or the Commonwealth has no control over the qualified examiners and how they prepare their reports.
Well, if there is control over how the trial's conducted,
Pardon me?
there is control over how the
Right,
trial
and
is
it probably would
conducted.
have made sense to put the police reports into evidence.
That would be a start.
The other thing I would point to is in this case that during the motions in limine, although Mr. PARISEAU's counsel moved to exclude them, when the discussion got into the Starkus and Givens case, he withdrew his motion and agreed that under the case law, they should be entered into evidence.
So you're saying this objection is waived then?
Yes.
Okay. Just to get back to it, 14C talks about police reports, doesn't talk about multiple layers of hearsay.
No,
Right,
it's the
so-
case law that talks about McCool, the case of McCool and SJC case, and then the Starkus and Given case talk about the hearsay, that evidence that is admissible. In the case of Given, there was no statements from the second victim that was allowed in evidence. In that case, the victim for which Mr. Given was found guilty said there was another victim, another child in the car, and that Mr. Given had sexually assaulted that child. There was no statements from that victim at all. The victim's name was never learned, and yet under Given, the SJC allowed that evidence to be entered into evidence. As far as the risk labels are concerned, this argument has been heard many times before this court. It's never found to be an error to enter them, and if it is an error, it clearly had slight effect. In this case, two of the doctors, two of the qualified examiners, each mentioned the risk label once. It's in the report once. It was not mentioned in closing. The recidivism rates that are associated with the score that Mr. PARISEAU had on the static 99 were before the jury, as was the numbers of what the average sex offender recidivates against. So the jury had the average rate, and they had Mr. PARISEAU's rate.
So that was what, 5 to 15% is the average rate, and he was what, 12.5?
Yes.
He was classified as a 5, is that right?
He scored a 5 on
Scored
it,
as a
yes.
5?
That's with 3 points reduced for age, because he was over 60 years old in the static 99R, you lose 3 points for age, or it's reduced by 3 points for age because age does have some effect on likelihood to reoffend. And finally, as far as the closing argument, first, that was also waived. There was no objection at trial. The motion in limine that Mr. PARISEAU's counsel brought purely went to the Commonwealth not being able to say to the jury, your job is to protect the public. There was a case, the LaPon case, where that had occurred. So that was, if you look at the transcript, page 31 to 35, that's the discussion at what couldn't be said. Nothing about likelihood. The analogy was meant to illustrate for the jury how the likelihood of harm.
I'm going to cut you off there because you're only because I have a question to ask you, and
Sure.
we're not going to see closing arguments like this in the future, correct?
No, as a matter of fact, the prior case is Diamesis, which found in that
was
case
improper.
that it was an error but not prejudicial.
Right. Well, I understand your argument that there's no substantial risk because of the failure to object, but
And when
you
the
don't have to spend any time justifying what was said. It should not have been said. It won't be said in the future.
Right. As a matter of fact, it's not been said since the Commonwealth received the brief in Diamesis.
Okay.
It stopped then, not well before the Diamesis decision even came out.
Well, that's good to hear. Questions?
Thank you.
Thank you both very much. All right, the next case we have is Kenneth IVESTER III versus Francis Murray IV and others, 2024-0933.
Good morning, Your Honors.
Good morning.
Steve Grant for the appellant, Murray Enterprises, Inc. We're appealing on two grounds. First, that the court erred on the defendant's motion for directed verdict, which argued that the plaintiff lacked sufficient evidence regarding damages at trial. And secondly, that the verdict slip and the jury instructions contained prejudicial errors.
With respect to your first claim, didn't the judge specifically invite counsel to bring the issue of the sufficiency of the evidence with respect to damages to his attention post-verdict?
It did suggest that. In fact, I inferred from His Honor that he would be holding a hearing, if not immediately after the trial.
Was such a motion filed? I didn't see one in the record.
No, Your Honor. Instead, I filed a notice of appeal.
Okay. And where does that leave you under the case law in terms of the necessity of filing a motion, a JNOV motion, to preserve your motion for directed verdict?
As I understood the law, as I understand it, a motion for directed verdict can be appealed without subsequent filing of a motion for judgment notwithstanding the verdict.
And what case do you rely on for that
I
proposition?
don't have a case in front of me, Your Honor.
If the court encouraged you to file a post-conviction motion, why not go that route? It seems you might have been receptive to it.
Again, I was under the impression that His Honor would be dealing with it after the trial, about a week past.
Oh, do you mean sua sponte? Is that what your impression was?
Yes.
And when that didn't happen,
About a
of
week.
course you could have filed the motion then.
I could have. Instead, I did file a notice of appeal to take it directly to this court. Yeah.
But the motion for directed verdict goes to whether or not the claim should have been presented to the jury at all, and what you're challenging now is sort of the jury's verdict, the damages being excessive, right? And I guess the problem, it's not just a technical matter, like this issue was actually never presented to the trial judge, so it's not clear what we're reviewing, right? There has to be a decision made that you claim was erroneous, but by the judge not addressing it sua sponte and you not making a motion, it's not clear what are we looking at here?
Well, we're looking at, again, the lack of evidence on the record as to damages, where the judge himself stated that the damages were speculative.
Did you file a motion? There was also no motion for emitter, right? There was no motion to say that the amount of damages should be reduced.
Correct, Your Honor.
Okay.
And so you're really pointing at IVESTER's testimony that it was about $1,000 a day he was losing for the bulldozer being on Murray's property?
Yes, I mean, IVESTER himself admitted on cross that his damages were speculative. These were over my objections. For example, he said at the time of the alleged conversion, he was probably charging $125 an hour, about 3 times a week, about $1,000 a week. And he only testified regarding lost profits as to revenue. He didn't testify at all, let alone any documentary evidence or expert testimony. He only testified as to revenue. He did not one iota of testimony regarding expenses. I don't know how you can, a jury can calculate lost profits when you don't have any record of expenses. How do we even know that Mr. IVESTER was running a profitable company? You know, proof must be made with a reasonable certainty, yet maybe not mathematical precision or exactness. And again, even the court stated that Mr. IVESTER did not meet that standard. Even Mr. IVESTER testified that he was speculating.
Well, to be more specific, the judge didn't necessarily say that the standard was not met. He said it was questionable. He was going to follow guidance and submit the issue to the jury so that we would have a jury verdict in case he decided that, that the post-verdict that there was sufficient evidence, or if he decided that and the case came up to us, we decided something differently. So,
Well, respectfully, at A487 of the appendix, His Honor said, the lack of evidence of any direct expenses related to the so-called lost revenue that would be necessary for a lost profits award of damages was, quote, not proven with reasonable certainty. At 441, he says, there was a deficiency in the evidence for damages. The damages are speculative. There was no such evidence of damages. And that's regarding lost profits, of course. And regarding the cost of the boiler, IVESTER said its value was roughly, over objection, $60,000 to $65,000. And then over objection, he was allowed to testify that the current value was $180,000. However, I think George versus Coolidge Bank makes clear that conversion damages are measured by the value of the converted item at the time of the conversion. And the burden of proof is clearly on the plaintiff to establish the fair market value of the bulldozer at the time of the alleged conversion. And Mr. IVESTER also had contradictory testimony. On direct, he said he was paid by the hour. On cross, he said he was paid by the job. In his complaint and on direct, he said, he indicated he was renting out the bulldozer. On cross, he said, well, we're not much of a rental company. So like the plaintiff in, I think it was McDonald's v. Hawker, his testimony was ambiguous and contradictory. Any questions?
I'll check with the panel. Any questions? No? Any questions? The panel has no questions. Thank you very much for your argument.
If it please the court. Walter Jacobs for Kenneth IVESTER. I believe the panel is correct. The defendants failed to preserve the issue of the directed verdict. They were repeatedly advised by the court that if they wanted to preserve that or hear further argument, they should take that up with post-judgment verdict motions. There were no post-judgment motions of any kind filed in the case. Therefore, they've waived that argument as far as the issue of directed verdict and the issue regarding the conversion and the value of the bulldozer or the lost income. With respect to the verdict slip in the jury instructions, in my brief, I've tried to outline by copying transcript information that the court and the parties entertained with respect to the verdict slip and to the jury instructions, and both sides were given ample opportunity by the trial judge to express what they thought should be in jury instructions and the verdict slip, and the judge very clearly on the record entertained all the suggestions from both sides in trying to fashion the jury instructions and the verdict slip, and in the end both sides agreed with those instructions and that verdict slip. So my argument would be that both sides basically have waived.
Not sorry to interrupt you, but didn't I read at one point, and please correct me, that the judge said anything we've discussed and what you've submitted, your rights are reserved, right? Didn't he say your rights are preserved? Excuse me.
I believe in the trial he did indicate that the parties' rights were reserved as far as any arguments they made, but ultimately both sides agreed with the instructions as they were modified by the court based on the interactive discussions with counsel and the court.
Okay. Leaving that aside for a moment, is it true that you view that the objection that that your point is that it was later waived, but the initial objection was to the word reasonable demand on the part of your client to have the bulldozer returned? Is that the crux of the issue?
Yes, I believe those issues were waived because both sides.
I know you know they're waived, but I want to make sure that that's what the objection is. If we were to disagree with you, for example.
Yes.
Okay, that's
Yes,
what we're talking about. The insertion of the word reasonable demand.
That's correct.
Okay.
I believe the judge was in the instruction, was implying and telling the jury that it needed to be a reasonable demand, and the jury, if they decided it was not a reasonable demand, then they would side in the opposite on their response. If the demand were unreasonable, then the demand would have been improper. But that was left to the jury to decide whether or not it was a reasonable demand.
And with respect to the proposed jury instructions and the proposed jury verdict slip, there was never a separate question to refer to whether or not your client's action was reasonable or not reasonable. There was never a separate, no one proposed a separate issue on that topic, right?
That was not in the verdict slip or the jury instructions.
No, I know in the final it wasn't there, but it was not proposed by either party either to have it separate.
That is correct,
Okay.
Your Honor.
Just wanted to be sure.
That is my recollection, correct, Your Honor. And I think that one other aspect that the jury was faced with is based on the trial testimony, which I've indicated in my brief. Mr. Murray had to testify that his testimony was in contradiction to his signed interrogatory responses. He also had to testify that he had never responded at all to 93A. How much credibility the jury gave to his testimony is unknown because we don't know what was deliberated by the jury and what weight they gave to the different aspects of the case that were presented to them. Any other questions?
Well, the verdict tells us a little bit about that, right?
Correct, Your Honor.
I'll see if there's any other questions.
Thank you, Your Honors.
Thank you both very much for your argument. We appreciate it. Next case is Grafton and Upton Railroad Company versus the Town of Hopedale and others, 2025-0028. Good morning.
Good morning, members of the panel. Andrew DeCenzo on behalf of the plaintiff, Grafton and Upton Railroad. In this case, it is undisputed that Grafton and Upton Railroad had a subcontract with respect to an EPA remediation project that was worth in the millions of dollars. That contract was unexpectedly and without notice to GNU canceled, and only after the fact did GNU learn from its contractual counterparty that it was canceled following mounting threats and pressure from officials of the town of Hopedale. Despite those allegations, the trial court dismissed on a Rule 12b-6 motion GNU's complaint after determining that the amended complaint did not adequately allege that the defendant local officials acted with sufficient improper motive, means, or employed threats when they caused or allegedly caused the contract to be canceled. We ask that this court vacate the judgment of dismissal and remand for further proceedings and for discovery to take place leading to summary judgment or trial. I'd like to begin briefly by addressing what we believe the Superior Court got right in this case. and that is in rejecting the defendant's invocation of immunity under Chapter 258, the Massachusetts Tort Claims Act. Section 10 of the Tort Claims Act, again, Chapter 258A, has been described by the Supreme Judicial Court as
I'm sorry, you don't have to defend we understand the issue here. The issue, because this is an intentional tort made against government officials in their individual capacity, right? That doesn't get protection under the Tort Claims Act. The issue is whether the common law immunity that protects government officials, government employees, applies, right? And to establish the common law immunity, you needed to allege facts that each defendant was acting in bad faith or with malice or with corruption in carrying out their official duties. So the question is, did you do that? And the judge said no. And I guess did you establish that they were acting without authorization?
So that is part of the allegations of the amended complaint, that the local officials were acting outside of their authority, for example, by using personal email addresses, by not complying with the open meeting law, and essentially...
But not complying with the open meeting law, I mean, that happens unfortunately quite a lot in the Commonwealth. That doesn't mean people are outside the scope of their employment, the scope of their duties, right? So you need something more, someone doing something kind of recklessly unrelated to their official duties, and I'm not sure you've alleged that here.
Well, so that, Justice Toone, goes to the threshold issue of, does the defense apply in the first place? Are they making discretionary decisions within the scope of their duties? And I would contrast the facts alleged here with the facts of the South Boston Betterment case, which was a suit involving the construction of the convention center and an agreement purporting to benefit the community of South Boston, and there was an allegation that Mayor Menino wrongfully interfered with that agreement. And there, the SJC said the mayor is the chief executive of the city. He has an obligation to ensure that the city is complying with the law and complying with lawful contracts. And the alleged wrongful action in that case was he was directing employees not to comply with the contract because he alleged or he took the position that it was not valid. And the court actually ended up agreeing with Mayor Menino on that piece. And so in addition to the contract being invalid, they said, well, he's the mayor, he's the chief executive, this is within his scope of authority. Here, the defendants certainly allege that they have a generalized responsibility over water quality in the town of Hopedale, and we don't dispute that. What we do dispute is that they had any role to play with respect to this particular contract in this particular land. And there's been no argument made with respect to any CMR, any statute, or anything other than that general authority, that this contract and this project fell within the oversight or the enforcement authority of the Water and Sewer Commission.
I mean, don't municipal officials like this have a general obligation to converse and speak with other agencies that share responsibilities similar to their own, right? I mean, talking to the EPA, talking to state agencies, right? That's part of the job of being a member of the Water and Sewer Commission, right? So what did they do that went so far beyond their general responsibilities that says, at least at the pleading stage, they're not entitled to common law immunity?
Yes, Your Honor, and the way you frame that question, I think, goes to the case that the Superior Court judge relied on here, which is that Nahas Realty case out of the First Circuit. And looking at the First Circuit decision and the District Court decision in combination, the facts alleged against the local officials there they were speaking out at public hearings. They were taking their concerns in public to other boards in the town. Here, the allegation is this is going on in secret, and GNU had no opportunity to even know it was happening, let alone respond, defend itself. And this course of conduct proceeded over a significant amount of time and resulted in this contract being canceled as a complete surprise.
So specifically, what did Mr. Watson do?
So, admittedly, Your Honor, the allegations are significantly more specific as against Mr. Burt.
So what did Mr. Watson do?
Mr. Watson attended that initial meeting that we believe was the genesis of this strategy from the town of Hopedale and the officials to cause this contract to be
Say
canceled.
the town of Hopedale, are you referring to Mr. Watson and Burt, Mr. Burt?
That's correct, yes.
Just those two?
Yes.
So what did Mr. Watson do other than attend the meeting?
So we don't have specific allegations with respect to Mr. Watson on what he did, and I think that goes to the issue with this case being disposed of at Rule 12b-6 at this stage. We allege that they acted in concert.
Not they. Well, you say he and Mr. Burt acted in concert?
That's correct,
What do you
yes.
point to for that?
That they were both present at that meeting and both involved in subsequent communications, and again, candidly, admittedly, the facts do point more to Mr. Burt because, and just going back to the stage that we're at this case, being 12b-6, the evidence that we have to rely on comes from public records. We haven't been able to get into discovery yet, and so we can only allege what we've seen to this point, but we believe that there is more.
As to Mr. Burt, he used his private email?
Yes.
Did he use his official title?
I'm sorry?
Did he use his official title?
I believe he did, and oftentimes in the communications referring to what was presented by Mr. Burt would be referred to as the town of Hopedale. He was holding himself out as an official of the town of Hopedale when he was performing these actions. And so, and I take your point and I take your question, Justice Desmond, on the allegations against Mr. Watson, the more specific allegations against Mr. Burt as to improper motive, and the tort, you can show either improper motive or improper means. Improper motive, we allege at paragraph 49 and 50 of the amended complaint that he had a longstanding animosity and ill will toward Grafton and Upton Railroad.
Right, so just to back up a little bit, when we're dealing with government immunity, right, it's a little tricky at the pleading stage because there's a general presumption that government employees are immune for stuff that they do within the scope of their duties. And so therefore, as a plaintiff, you have an obligation to kind of plead facts to show they fall outside that general immunity. And the standard here is in bad faith with malice or corruption. Now, you do allege that these defendants demonstrated animosity and ill will towards your client. And, you know, that's probably a common perception among regulated entities that regulators are behaving in a way of ill will or animosity. I'm not sure that's enough, though, to get you where you need to. You actually have to plead malice, bad faith, corruption, right? And I just don't know if your allegations get to that level. That's the challenge for you, I think.
And I understand your question about that being a common perception among businesses subject to local regulation. I think it's important to point out in this case that was also the perception of other town officials. And we allege at paragraphs 55 and 56 of the amended complaint that Mr. Burt was told by a town administrator that he had to stop conflating his own opinions and his grievances against the railroad with his work as an official of the town of Hopedale. And
Was that against the railroad or against really against the fact that there allegedly hazardous materials were being transported through the area?
So this was in
And
relation.
what was it that was against your client personally? Where was the evidence of the personal animosity that you allege?
This was in relation to a separate issue, so this occurred prior to the initiation of the contract at issue here. And so the allegation is that this animosity was continuing and continued from the prior issue, which was back in 2021, and continued on to this next opportunity to stand in the way of Grafton and Upton Railroad's activities in town. And so just to back up briefly, the common law immunity issue wasn't raised below, and there's certainly authority for the proposition that a judge can make an order sua sponte on that issue, but that may be something that could have been more developed below. And then we also discussed...
It wasn't raised, I'm sorry, because they just asserted straightforward immunity under the
Tort
Claims Act. Okay.
Correct.
Okay.
And I would, just because the questions regarding the sufficiency of the allegations, I would refer the court to, there are a number of cases, but I think the most illuminating is a recent unpublished decision from July. It was the O'Hara versus Revere case. And Justice Vuono, I think you were on the panel for that one. So that was post-briefing. It's not referred to in the briefs here, but I think...
And you didn't file a letter giving us that information, correct?
No.
So would you give us the case number, please?
It's 105 Mass App 1138, and it was a July 2025
1138 or 08?
I'm sorry?
1138 or 08?
38.
Thank you.
And there, the panel said that the plaintiffs alleged that Capizzi's actions were done, quote, out of retaliatory animus and a spiteful purpose, as the judge properly noted, at least at this early stage of litigation, that was sufficient to allege Capizzi's decision was not in good faith, without malice, and without corruption. And I do think the allegations that we have put forth here are sufficient. And I would also go one step further because, again, this goes to the fact that we are at Rule 12b-6, but there is direct references from GNU's counterpart to threats and to pressure. And because this is happening, we're considering moving to a different rail yard. And as the plaintiff at the Rule 12 stage, there should be an ability to conduct discovery to determine what were the nature of those threats and the nature of the pressure that was put on by these local officials. And we should be permitted to move into the discovery phase of this litigation. Thank you.
Any questions? Thank you very much.
Good morning, Your Honors. David Mackey and my colleague Sean Grammel from Anderson Krieger representing the defendants, appellees Ed Burt and Tim Watson. GNU's claims against these two municipal officials, and they're labeled as individual capacity claims, seek more than $10 million in damages from them for tortious interference and violation of the MCRA. How did this allegedly wrongful conduct occur? Well, GNU is very specific. It's basically 14 emails that defendant Ed Burt, who is the elected chair of the Hopedale Water and Sewer Commission, sent to federal and state officials, almost all to the EPA, expressing honestly understandable concern about the effect on Hopedale's water supply of GNU's transloading of more than 100,000 tons of contaminated soil at its transloading facility. Now, Tim Watson is also a defendant here. I'm not going to say too much about Mr. Watson in the time I have because, frankly, GNU says almost nothing about him. All they allege in their complaint, they don't allege he wrote a single email to anybody. All they allege in their complaint is this sort of boilerplate repeated paragraph after they describe each of these emails, and again, on information and belief that Mr. Watson consulted with Mr. Burt, and that just doesn't get you anywhere under 12b-6. Now, there are several bases in our view to affirm the Superior Court's dismissal. First, the amended complaint fails, as the Superior Court found, to overcome the presumption that these two municipal water officials were motivated by concern.
Can we just stop there for a second? So there is a legal question. Does the presumption in favor of government officials' honesty and motives apply at the pleading stage or only later at summary judgment and trial?
100%, Your Honor.
Well, I mean, Judge Mastriani held that the presumption does not apply at the motion to dismiss phase, and he's a federal judge. That doesn't mean it's binding on us, but it's, it's important. And so you think he was wrong?
Well, we do. It's a little bit hard to read exactly what his opinion means, but let me start with, we understand GNU says, no, you can't deal with the 12b-6. The Nahas Realty case, just mentioned, First Circuit, 12b-6, dismissal based on common law immunity.
Did Nahas deal with the presumption or?
It was the presumption.
It applied to presumption?
Yes, Your Honor, I believe it was based on the South Betterment Trust presumption that officials are acting in their official capacity. And I think they literally quote all that language from South Boston. There are other cases that we cited, the Bache versus Boxborough case, 2022, DMAS, Summers v. Fitchburg, 2016, DMAS, Lee versus Quincy Housing Authority, 2017, DMAS, and the City of Boston versus Massachusetts Gaming Commission, an opinion by Judge Sanders in 2015. We've cited all of these in our brief. Every one of these is a Rule 12 dismissal on common law immunity grounds. Yeah. And all the way, they're also, by the way, all intentional.
Well, I'm not saying your clients aren't entitled to common law immunity. We'll decide that, but just the question is, do you apply the presumption? How do you apply a presumption like this at the pleading stage, right? Because we're not really weighing evidence. We're assessing whether the allegations are sufficient to sort of state a claim, and that goes to whether or not, as I understand under the common law immunity rule, was there malice, was there corruption, was there acting beyond the scope of an official's authorized duties, right? That seems to be the issue.
Right. So in the South Boston Betterment Trust case, and by the way, I should say, the Supreme Judicial Court has said in this AIG case that once the defendant raises common law immunity, the burden of overcoming the immunity rests squarely with the plaintiff. And, this court has also recognized, as has the SJC, that immunity needs to be decided at the earliest possible stage in the litigation, because it's immunity not only from the horrifying $10 million damages claim, but also from having to participate in a case like this, which is obviously extraordinarily stressful and expensive for these individuals in the town and everybody. So, according to South Boston Betterment Trust, there is every presumption in favor of the honesty and sufficiency of the motives actuating public officials in actions ostensibly taken for the public welfare. And a public official is not liable if he acted in good faith, without malice, without corruption. So based on that standard, the Superior Court looked at the allegations in the complaint, looked at these 14 emails, and invite this court to do so as well. It's about 50 pages of emails, and they're all in the record. Mm-hmm. And he said, these are basically communications of and actions by Burt, again, almost all to the EPA, and to a lesser degree Watson, though Mr. Watson didn't write any of these, to express in good faith their concern as members of the town's Water and Sewer Commission and or department, because Mr. Watson's manager of the Water and Sewer Department, that GNU's transport of waste could impact the town's water supply. And in reaching that conclusion, then it pivoted to the Nahas Realty case, which is a remarkably similar case, where, in that case, the plaintiff labels defendant's concerns, like GNU does here, as malicious and retaliatory and bogus. But the First Circuit says, even with those labels, the complaint fails to state a plausible claim that bad faith or malice, as opposed to concern for the town's general welfare.
Well, what about the issue that Mr. DiCenzo discussed with Judge Vuono about the email about Burt not being able to separate his personal feelings or from his duties? That seems helpful to their position.
Well, the problem with that email is that it was written, if I'm recalling the record correctly, in February of 2021. That's before the principals at this Superfund site had even developed the plan for how this material was going to be transloaded. 18 months later, the first of the emails written by, Mr. Burt, is sent. So it's relating to a different issue, and it's a year and a half before this even begins.
Isn't the point of your brother that it shows a level of animosity that he's also relying on, somewhat broadly, but that he's alleged?
Your Honor, there may have been, ill will here. There may have been some animosity here. There may have been some frustration with the railroad. But the problem is that that is all animated by his concern for the town's water supply. This is 100,000 tons of contaminated soil being transloaded at Hopedale, a small town in central Massachusetts.
But that sounds like a factual, analysis, we're trying to determine this person's motives based on some emails, right? Is that for us to decide, or at the pleading stage?
Well, they are effectively in the pleadings because they're all referenced in the pleadings.
But you're asking us to make a judgment, like, wow, he didn't really mean it then, or it didn't kind of carry through these subsequent emails, and because he was really, how do we? It's very difficult to sort of come up with an assessment of Mr. Burt's intentions through.
Your Honor, it's
looking
up
at
to
the
the
complaint.
plaintiff, though, respectfully in our view, to come up. It's their burden to come up with plausible allegations that he was not acting to protect the town's water supply. He's an elected official. The purpose of the Water and Sewer Commission under statute is to protect the town's water supply. That's what he was elected to do by the citizens in the town. And in our view, those emails can't be read in any way other than his desire to protect the town's water supply. He was legitimately worried about this and wrote the EPA repeatedly about it. And whether, I guess I want to say a couple of things because it relates both to improper means and motive and to the MCRA claim. If you look at these emails, and we've cited, I think, 3 or 4 of them in our brief, if you read the emails, they're all written on behalf of the citizens and the town of Hopedale. He is referencing the community interests in these emails, protecting the town
Your brother's
of Hopedale.
point is that does not exclude that the motivation could have been personal animosity in addition to.
But, Your Honor, with respect to that, the cases are pretty clear that the motivation, that if the motivation is even in part to serve the interests of the public entity, that's good enough.
Sufficient.
And again, Mr. Burt may have been frustrated. He may have been persistent with EPA. He may have been annoying to EPA and DEP, but that's what elected officials in these positions are entitled to do. It was, petitioning activity because of his concern about what he learned this transloading plan was going to be
So the
about.
communication was that they were going to terminate the contract because they didn't want to have to deal with the continuing threats, right? And so do they get to discover what the threats are, or do they just get dismissed out?
No, in our view, Your Honor, they do not. Because first of all, case law is pretty clear that, threats, for example, it doesn't work if there's sort of a colloquial statement of a threat. Threat has a very specific meaning within the MCRA, for example. And I just give to the court the case law on threats. It has to be the intentional exertion of pressure to make another fearful or apprehensive of injury or harm. And almost all the cases involving threats involve fearful or apprehensive of physical injury or harm. It, as I say, typically involves actual or threatened physical harm. Given the content of these emails, which are all expressions of concern for the town of Hopedale, and honestly, given the tone of the emails, they're professional, they are respectful, they conclude with "thank you for taking the time to engage with us, this is all very reassuring." There's just, it's simply not plausible to imagine.
But to Justice Desmond's point, let's say we agree with you. We review the emails, they're in the record. We don't think that arises to any kind of a threat or ill will, et cetera. But there is an allegation in there that the contract was terminated because of being fed up with all of these threats and bad publicity and things like that. And to Justice Desmond's point, how do we find, at this stage, is it up to your opposing counsel to allege more specifically what they were? And if so, how does he find that out without discovery?
Your Honor, there simply isn't enough at this point to even state a plausible allegation. We have no idea who those threats came from, whether it was Hopedale, whether it was another community. We have no idea what those threats were. We have a sense that...
But the question is, how do they find out?
Isn't that the problem, right? I mean, they say Hopedale won't come back because of the threats, right? Isn't that kind of what they say in the papers? And so doesn't he get to find out what specifically are those threats?
There is, I think, simply using the label threat, a subjective feeling that honestly the individual who wrote the email wasn't the person feeling the threats. He was apparently characterizing something that someone at U.S. Ecology had said. But again, there's no indication that Mr. Burt or Mr. Watson ever threatened anybody with anything. So an email that we don't know the source of somebody saying there was a threat can't be enough to get them across the line here.
Well, to find out the source of that could exonerate them completely as far as we know, correct? We just don't know.
I'm sorry, Your Honor.
That finding the source of that information could very well exonerate your clients completely. We don't know.
Except the problem is that's going to involve if that were to overcome the presumption of immunity here, simply by the word threat appearing in an email with no references to who it came from or what was stated in the alleged threat, that basically is going to subject these individuals to the very thing that the presumption of immunity is designed to prevent, which is ongoing litigation in this matter. Again, the case law is pretty clear. It's not someone's subjective understanding of, gee, they've been threatened. It's actually what the actions were. Can they be characterized as a threat? And the actions that the railroad has alleged here, under no circumstances could put anybody in fear of injury or harm.
We just want to be clear that the word threats did not come from your clients were informed of the fact that there was threats. They did not use that term, correct?
Our clients did not use that term?
Right. It says,
absolutely not.
Right. It says the communication came from the U.S. Ecology's vice president about that, correct?
Yes.
Okay.
Yes, Your Honor, I believe that's right.
Sorry to interrupt you there, but we were close to finishing. So.
Okay, no, I understand it. Let me conclude. I guess the emails, which are the actions, very specifically, that GNU is relying on here, don't come close to supporting an intentional tort or MCRE claim.
Okay.
Public employees like Mr. Burton.
Your time is up, so you can rest on your brief now. Thank you very much.
Your Honor.
Okay, thank you both very much for your arguments. Okay, we'll hear one more case before we take a short break. The Department of Children and Families and Others versus Mother and Another. Case number is 2024-1320. I remind everybody that this case is impounded, and we will not use any of the parties' names. I don't know. Looks like the parties might be out in the hallway. Okay. We got you a little bit faster than we thought, so welcome. That's perfectly all right, and you weren't far away, so it's not an issue. So just so you know, the case has been called 2024-1320. As you all know, the case is impounded, and so we won't use any names. And we're ready to go. So, Attorney Lockhart.
Thank you. May I please the court? I am Lily Lockhart for the appellant mother. In this case, the evidence of mother's parental any unfitness was not current. The primary concern in this matter was substance misuse by mother and father, which mother had acknowledged She had demonstrated her current stability. She had, but the positive facts of her stability were largely ignored by the trial court.
Well, when you say she demonstrated her current stability, can you point to some direct facts and facts that the judge found credible, not the ones that the judge found were not?
Yes. So I think one big fact was Mother's working history. So Mother had been working at the Dollar Tree for at least 18 months consistently, and she had been promoted to a managerial position, demonstrating that, at least in the eyes of her employer, she was consistent, responsible, and somebody that they were going to entrust with those added responsibilities of managerial. She did have stable housing, which I know had been provided by paternal grandfather, but it was still a source of stability, and again, she needed to be consistent with that. DCF, when they did in fact go out for a home visit, the home was appropriate. She had, there were no safety hazards. She had space set up for the children. In the time leading up to trial.
DCF, did she allow DCF to do the home visits? With some
Initially, in the beginning of the case, there were some issues and there were some times where she declined visits, but in the year before trial, she was not declining home visits. And in fact, the DCF social worker who was assigned to the case at time of trial testified that she essentially just didn't ask about doing home visits. So there were no home visits for the 6 months before trial started. And then DCF, after about 2 months of trying to make some arrangement to have 2 workers go out, did a home visit in May of 2024, and then did a subsequent home visit during the trial. And during those home visits, the report was that everything was appropriate, Mother was appropriate, and the home was fine.
And with respect to her employment, doesn't the judge kind of say, well, yeah, she should be credited for the employment, but she actually was kind of putting that over the needs of the children and her sobriety?
I think the issue with employment in these cases is that it turns into parents end up really stuck between a rock and a hard place. The department wants to see people employed. They want to see financial stability. They want to see continuity. They want to see those hallmarks. But then they want the parent to do services and visits in the middle of the day. And when a parent is working at a employment at will situation and they have to go and show up for work, then they're, turn around and say, well, but you didn't show up for this, and you didn't show up for that. Additionally, I think in this case, the mother testified that her employment and the consistency with that was really a cornerstone of her sobriety. So it was a big part of her stability in a more clinical sense as far as her recovery from substance misuse. And that, was, and I think that the court was in the wrong and did err to sort of hold that against Mother. The court really only had one finding of fact about Mother's employment. It was just sort of a brief acknowledgement that she was employed, and really didn't examine the implications of what it meant that she had had that consistent employment. Additionally, Mother was engaged in an IOP during the time of trial, and she did, I did just want to note there was some discrepancy. The DCF brief notes that Mother had been offered 80-some days of treatment, and it is a little bit confusing when you look at the records because of the way that the attendance is noted, but it is clear from the records that fairly early on in the program, she went down to a 3-day a week. So really, she was only offered 57 days, and she attended 35 days. I would also note that the records are dated June 15th. That's when they were brought into court. But the trial itself went until July 14th, and the testimony indicated that Mother was continuing through the program during the trial. She did ultimately complete that program. She did attend at least those 35 days of treatment. She met with a substance use counselor. She was able to speak in her testimony about the triggers that she had identified, coping skills, relapse prevention plans that she had in place. And all of her toxicology screens were negative for all substances during her time in that program. Additionally, for approximately 2 years before trial, at all visits, Mother was always sober and appropriate with the children. And they're really, the only positive toxicology screen that was ever put into evidence was from 2022. At that point, I would argue that that was stale.
Has mom taken any parenting courses?
I'm sorry, Your Honor.
Has mom taken any parenting courses?
Mother, I do not believe, did any parenting courses. However, again, the focus of the case was really on mother's substance misuse. The facts were that mother actually had a background in early education teaching. She had a degree in early education teaching, and her testimony, which was found to be credible, was that she had worked in daycare centers before she'd had children and become a stay-at-home parent. So I think that, again, the primary concern and the focus of the department's requests of her were to engage in substance misuse treatment.
Okay. Toward that end, did they recommend that she enter an inpatient program for substance abuse?
There were different recommendations at different times. My recollection of the action plan was that it was not specifically for inpatient. I know there was some testimony about that. Again, mother testified about some of the difficulties about being able to get into those programs. And additionally, she did have a lot of work stability, and going into an inpatient treatment program would have likely resulted in her losing her job entirely. So I think she was really balancing those demands. With regards to I would just note briefly that with regards to the instances where the court did find mother to be not credible, the case law indicates that a finding of not credibility does not prove the opposite fact. So the court simply finding that mother was not being honest about certain things doesn't mean that the opposite is true. And there are undisputed facts, again, about her employment, about her housing stability, about her attendance at visits, and the Elevate records, again, speak for themselves as far as attendance and the toxicology screens. Secondly, the court impermissibly shifted the burden onto mother to prove that she was fit at the time of trial. The court asserts that it's not shifting the burden, but then goes on to say that mother did not establish that she was sober. The department did not present any positive toxicology screens after 2022. Mother should not have been required to have rebut anything because, again, DCF did not provide any current positive toxicology screens.
Wasn't the judge really getting more towards a credibility determination at that point rather than putting the burden on your client to prove fitness?
I'm sorry, Your Honor. I just missed the
Could you
beginning.
also view that particular discussion to be one addressed to credibility rather than being addressed to a shifting of a burden to your client to prove fitness or to prove sobriety?
So I think, again, I would go back to the issue with the credibility findings is that the finding around credibility and the finding that she was not being honest does not prove that she was misusing substances.
Well, I understand that point, but you also said that there was a burden-shifting argument here. And what I'm trying to get drill down on is that could it equally be interpreted as comments regarding credibility rather than shifting the burden, in your view?
So I think the issues around credibility were statements around her relationship with her husband and his involvement and some specific incidents, as well as some prior engagement. Again, I think the evidence in the 6 months leading up to trial were the records from Elevate with that IOP, those positive screens. So I think the court statement was that mother had not demonstrated her sobriety. So that statement was really zeroed in just on the sobriety piece. And I think that's where the burden shift happened. And I don't think, because again, I'm relying more on the Elevate records rather than mother's testimony or any issues where mother was found to be not credible.
Okay.
Are there any specific findings that you challenge?
I'm not challenging any of the specific findings. I'm challenging the fact that the court did not take into account the evidence that was presented in its totality. So more the lack of findings around mother's employment, the lack of findings around her treatment at Elevate, as well as the criticism, I mean, the failure to acknowledge that employment was a constant stability, a demonstration of stability on mother's behalf, as well as a source of stabilizing her and her sobriety and her recovery. And the fact that then that was turned around on her and used as something that she was faulted for as far as missing days of treatment and missing visits with the children. Because she was in a managerial position, so there were times where she was needed to come in at last minute notice, cover other people's shifts or do other things within the store.
Was there evidence that kind of made that link between her working at the Dollar Tree and her non-attendance at treatment or?
So that, I think that was mostly came from mother's testimony. She spoke about, she was questioned about missed visits as well as missed dates at the treatment program, and she testified about demands with her employment and that because of her role that she would often be called in sort of last minute, and that if she did miss work, that would jeopardize her employment, even if she was called last minute.
I totally take your point about the judge seeming to underplay the importance of her employment, but it does, the expectation of parents is they have jobs and they also meet their other commitments, including, treatments and visitation issues like that. So it's hard to know how to assess this issue and say the judge was wrong in that assessment. That's the problem here. I'm not sure what do we do to sort of question the judge's conclusions with respect to missing appointments.
So again, I think, yes, that tension exists in many of our cases. I think for clients who are living in a lower income bracket, who are living more on the margins, that tension is more so because there's just less flexibility with an employer. An employer is going to be able to terminate you very readily. And I think that what I fault the trial court for in this situation is the fact that the trial court did not sufficiently acknowledge mother's employment and what that meant. So yes, there is that tension, but the trial court did not delve into those facts and did not fully analyze those facts. There's rarely a very cursory mention of mother's employment and then just sort of goes on. And focuses more on the older evidence that DCF had presented around mother's substance misuse. I would also say that even if, and I'm not conceding that mother was unfit, but even if this court finds that there was sufficient evidence that she was unfit, that unfitness was only temporary and her parental rights should not have been terminated. Mother acknowledges that she'd had a long history of substance misuse and she had relapses, but it's fairly well settled law at this point in time that relapse is part of recovery. At the time of trial, she was on that path to recovery. We don't have any clear bright line rules about how long somebody needs to be sober for, what that needs to look like to know that they are sufficiently in recovery to be fit. But mother had done the treatment program. She did have a series of at least 8 negative toxicology screens during those few months. She did have 35 days of attendance. She was able to speak in her testimony at trial about her acknowledgement of her past misuse, her knowledge about what her triggers were, her efforts to make sure that she maintained her sobriety. Additionally, the department had failed to make reasonable efforts with mother. I think the biggest issue was the failure to go out to see mother in her home. And while that is, a line in the regulations as far as going out, those home visits really are substantive. This is an opportunity for DCF to see the home, to observe the parent, to talk to them, find out how they're doing, find out what barriers there might be, to engage in additional treatment, get feedback, assess their progress in treatment, their engagement with those services, and those opportunities were entirely missed. And the social worker's testimony was essentially that in the past, mother had declined visits, so she just stopped asking. And even towards the end, the DCF social worker testified that they were unsure of the safety in the home, which again is a bit unclear because there weren't any specific indications of unsafe situation, but it seemed to take them about 2 months to come up with a plan to basically just have 2 social workers go out to the home for the home visit as a safety precaution. Thank you.
No further questions. Thank you very much for your argument.
Thank you very much.
All right, we have a split between the next two attorneys. And for the department, 8 minutes.
Yes, thank you very much. Lynn Murphy for the Department of Children and Families. The trial court properly terminated mother's rights here, where after 2.5 years of services, she had not obtained sobriety. She did, 2 years into the case, finally enroll in an intensive outpatient program. However, she was missing significant amount of the sessions, and the court reasonably found that her sobriety as a result was not remedied at that time.
What about the judge's references to the mother's failure to demonstrate her sobriety? Was that proper?
Well, I think what the court was trying to say, right after the court says that, the court says, I'm not putting the burden on mother. I want to explain that I'm not expecting the mother to prove this. But the problem with the mother, she would not participate in certain screens. So that's why in 2023 there was no toxicology screens that were positive, because there were no screens. Yeah. So I think what the judge was trying to say is she wouldn't cooperate to the point that there would be evidence. And that's basically the 2.5 years that the department was providing services. This was a major piece of the problem. His mother did not want to cooperate. She was not honest with not only the department, but many other service providers. And this is what I think the judge was getting at, not saying that the mother had the burden of proof, but saying mother didn't cooperate. There was evidence that...
Right, but the absence of evidence is not evidence itself, right? And so I guess what was the evidence of her not being not sobriety after 2022? Is it just because the failure to kind of always attend the treatment center? Is there anything else?
Yes. Well, I think the important thing to remember, this is a 20-year history of significant substance abuse. And the inability or unwillingness to engage meaningful in any treatment during those 2 years. And not only did she not do substance abuse, there's no therapy. She wouldn't visit consistently. When she appeared for some visits, she seemed under the influence of intoxicating. She was inebriated. She continued her relationship with the father, who was in a similar, maybe even worse state. So the evidence was that this was a person who had a lengthy history of abuse, and there was no change except for that very short period that there were clean screens. But again, the screens were not random. They were scheduled. They were not supervised. And I think the court acted absolutely within its discretion to say this 4-month period or 3-month period where you have negative screens is insufficient for me to believe that you've overcome this significant substance abuse problem after 2.5 years. And it's, again, 20-year history. We're not talking.
But one of the things we look at when people are getting their lives together, right, is employment. And here the evidence was the mother was working for 3 years at Dollar Tree. She was a store manager. She supervised other staff. She handled cash deposits. That's work. I think being a store manager at Dollar Tree strikes me as a demanding job with a lot of responsibility. And there really wasn't much mention of that at all in the judge's decision. One paragraph. I found that surprising because that seems like an indicator of other things going on, and the judge really didn't give that much consideration at all.
Well, I would disagree that the court didn't consider that. I think the court did. But the problem, again, is mothers had been employed in that position during some of the worst times of her insobriety. In fact, she was working there for about a year or around that time, 2022 was when she began employment. And she admitted her unfitness thereafter. So even though she was able to hold down this job, we don't know how many hours she testified that there were various hours. But however, despite her employment, she still struggled. She was not able to maintain sobriety or visit the children. And I think the court was well within its discretion to note that the priority of the mother was not for her treatment or visiting her children. And that was a significant factor. 2023, she wasn't visiting those children for months on end. And at that point, the department was ratcheting down. The mother started with weekly visits, then we had twice monthly, then we had monthly. And it wasn't until the department changed it to monthly that she was able to participate a little bit more consistently.
Oh, sorry, go ahead.
When was the last time the children were in mom's care?
I think we removed 2021. So
How did they present prior to that?
How did they present prior to the removal? Well, here's what happened. We were involved in a 51A. We tried to provide services earlier on, and the parents rejected them. So we didn't get involved again until mother had a significant incident at the hospital with the son, and then we removed pretty quickly. In fact, we did remove because there was a history there, even though they wouldn't participate. So we didn't, so once the children were removed, then we saw the neglect. The children's teeth were rotted out. They were both overweight. They both missed school, particularly the daughter. So the neglect that the children faced was very apparent once we removed.
Just going back to the issue about the mother testified the reason I couldn't make all these treatment commitments was my job, the inflexible work schedule that I had, and I didn't want to lose the job, right? And so that might be true, that might not be true, but the judge didn't really engage that explanation. It was just, the finding was the court finds that mother did not prioritize her substance use treatment, right? There's no sort of, I don't believe the story about the job, I do believe, or it's not, there's just no engagement with that kind of testimony. And isn't that something the judge should address?
Well, I think the judge did, and it wasn't only, remember, it wasn't only the work schedule. Mother had a variety of excuses that the court did not credit. She said something about, well, my father was sick and I had to drive back and forth to New Hampshire every day, and it wasn't only that wasn't the only reason the mother proposed. And the judge did say in the findings, the mother had a variety of explanations or reasons that she didn't do treatment and couldn't visit, but none of them were found credible. I think that's well within the court's discretion too, so fine, given.
But what is mom to do? If she had attended the visits and had gone to the testing and lost her job, then wouldn't we be saying, well, mom's unemployed and doesn't have a job and can't care for the children? So isn't she kind of stuck between a rock and a hard place, as between those two arguments?
Well, I think if that was a real issue and the mother was having problems and there was a legitimate concern that the department testified, the social supervisor said, we work with parents. We try to work within their schedule. We don't have visits. And I think even mother admitted that the visits were tried to be scheduled around people's work schedules. I mean, the department knows people work, and we do everything we can to try to make those visits possible in that schedule. But this, again, the history here is very clear. We had a person who had a very significant substance abuse issues, and she just had a very hard time, had a hard time recognizing the significance of that, which is why she was resistant to intensive treatment. And she would have these periods where she wasn't participating at all. It wasn't the work. It was she was not able to maintain sobriety.
Your time is up. I'm going to determine if there's any follow-up questions.
I have one more question,
yes,
actually.
Yes, sure.
Just to the visit issue by the social worker. So when a child is in placement, social workers are required to try to visit them every month? Is that correct?
Try to visit
with the parents every month?
Yes, home visits that is the idea.
And so here, the social worker testified that she was assigned in November 2023, but did not attempt to schedule a visit with the mother until April 2024. Is that correct?
That is correct.
And the reason for that was she didn't think it was going to happen, or?
I think the testimony was she was a brand new social worker. That was her first case. And I think what she said was something to the effect that there was 15 months where mother was asked for home visits and rejected it. Now, it does appear that she felt, or was, I don't know if she felt this or gleaned this, but she did not reach out immediately because I think she felt that mother would say no. And then she did reach out and scheduled it. So we're talking about a 5-month period over a 15-month period where mother refused to have home visits.
Yeah, okay. But that doesn't seem like ideal policy and procedure for
Well,
DCF,
and this is
right?
why I
To sort of
point
not,
out-
to sort of, well, she's going to say no, so I'm not going to ask.
Right,
Is
and again, she was a brand-new social worker, and should she have asked Mother immediately upon, as soon as she was assigned the case, should she have been continuing with that pattern of asking monthly? She should have.
Thank you very much.
Good morning. May it please the court, Roberta Driscoll-Weiss on behalf of the two children. If I could try to respond to some of the questions that have been asked so far this morning. Your Honor, Justice Desmond, you asked when this family initially became involved with DCF, and I would just point out that beyond the 51A that had been filed several year or so before this case opened, the DCF became involved in 2016 with this family because the second child was born exposed to substances. He was born because mother abused substances when she was pregnant. He was born early and required medical attention because he was born exposed to substances. So that was the first exposure that mother had to DCF was around the birth of her son.
He had codeine in his system, is that right?
I'm sorry.
Was it codeine that he was exposed to?
He was exposed to street Suboxone Percocet, is I believe the way it was described in the record. I couldn't begin to tell you what that means, but that's how it was described. He was born at 36 weeks gestation, suffered placental abruption, likely due to intrauterine substance exposure, and was actually med-flighted to Brigham and Women's Hospital for medical care. So that was the first go-around that this family had with DCF. DCF opened a case for services. The family failed to comply, and DCF closed the case for services. The family became involved again with DCF when the same child was hospitalized and mother was observed to be under the influence while she was at his bedside. And the children were ultimately removed from the parents' care on December 6th, 2021. There's been a lot of discussion, or my sister raised on mother's behalf, that there had been no positive urine screens for 2 years before the end of trial as evidence of mother's fitness, but I feel it necessary to point out that mother stopped providing urine screens in November of 2022. That's finding 101. So we can't rely on the lack of urine screens as evidence of her sobriety. It's not that there were no positive screens, there were no screens, period. In 2024, when she began engagement with the Elevate IOP program, she provided 8 urine screens in a period of 4 months. These are urine screens that were not given in an observed fashion. Rather, mother was able to go into the bathroom alone, unsupervised, and come out with a urine screen. There had been previous concerns raised by the trial judge that mother might, in her relation to her participation with a program earlier, that she had been purchasing urine to pass off as her own urine screen. So there was some evidence that she had not been, there was a question as to whether she was being completely honest with respect to her urine screens. I would point out on behalf of the children that, what's really at issue in these cases is the best interest of the children, and maybe DCF did not handle this case as well as they could have with the last brand-new social worker. But the fact of the matter is that these children were removed in 2021. The goal was changed in December of 2022. Mother still refused to engage in treatment until 2024. And her own words in the intake that she did for the Elevate IOP led those individuals to conclude that she presented with poor insight as evidenced by her inability to identify triggers, not attending groups, and isolating behaviors. This is at the exhibit volume 4, page 30. The program intake coordinator rated her judgment as fair and her overall level of impairment and severity as considerably impaired, diagnosing her with severe cocaine use disorder and severe opioid disorder. This was in 2024. By this time, these children had already been out of the home for years, and yet mothers' substance abuse continued to impact these children because 3 years later, they're still unable to return home to their parents. And there's case law that says that stability in the life of a child is important, and I would say in this case, it's the most important thing. And 3 years later, mother still had not gained any real traction with her substance abuse treatment that these children were ever able to come home. I would also like to address the issue of the burden shifting, which I think Your Honor raised, or has been raised a couple of times, and just point out that in the case of the Terrence case, which is at 57 Mass App Court 832, this court was faced with similar comments from the trial judge in that case, where the trial judge had made a statement to the effect that mother had not demonstrated a change in her behavior. And this court found that that was not burden shifting because read in connection with that judge's findings and the proper application of the factors found in General Laws, Chapter 210, Section 3, a handful of grammatical comments like that did not constitute burden shifting because the court placed the appropriate emphasis on those 210.3 factors. And I would say that, likewise, the fact that the judge recognized that the mother does not bear the burden of proof of her own fitness in connection with 177 findings of fact, none of which have been argued to be clearly erroneous, and 44 conclusions of law is more than adequate basis to support the judge's termination of the mother's parental rights. I would also point out that mothers, most of the evidence, at least in 2024, right before the conclusion of trial and 3 years after these children were removed, most of the evidence of mother's drug use came from mother herself, where she disclosed in the intake to Elevate IOP and other programs that she continued to abuse substances. So even in the absence of a positive urine screen, the record contains mother's own statements that she continued to engage in behavior that made it impossible for her children to return home. And so based on all of those factors, I would ask this court to uphold the judgment of the trial court terminating mother's parental rights and freeing the children for adoption.
Seeing no further questions, thank you very much for your argument. The panel, of course, is well aware of what's at stake in cases like this, and we'll look at the entire record very carefully and take the case under advisement and give you an answer as soon as we can. All right? The court will stand in recess.
Court all rise, please. Court is now in session. Please be seated.
All right, so it's still morning. Good morning. The next case before us is 2025-0045. Timothy Haddick, how do you pronounce the name?
HLADIK.
Gladdick, okay, Gladdick and others versus SII Investments, Inc., and another. Counselor?
Good morning.
Good morning.
Members of the panel. My name is John Sutherland at Brickley Sears, and we represent the plaintiffs Timothy HLADIK, Brian King, and Mr. and Mrs. Ralph Johnson. Mr. Johnson is disabled, and all of the plaintiffs are retired people. This is a case of broker theft. The comments to Rule 8A1 indicate that pleadings of conclusions are still allowed, and the respondent or defendants have the opportunity to file Rule 12E motions if they need a more definite statement. If there's something improper, they can file a Rule F, 12F motion and get something excised. Rule 8 still only requires a short and plain statement of the claim showing that the pleader is entitled to relief and a demand for judgment. That's what the rule says.
Right. So under Inancino, though, you have to allege sufficient facts to establish a plausible claim for relief, right?
Exactly.
And here, I guess the question is, the judge dismissed your complaint without prejudice, right? So you could have gone back and filled in the gaps here. You know, clearly, he said that the problem here was you alleged that the defendants converted your client's money. You put dollar figures on it, but you didn't allege exactly what happened. What did McGonigal do with your client's funds? And I guess the problem is when we're trying to determine whether a plausible claim was alleged, it just seems a very unusual gap in the complaint. You allege that McGonigal, am I saying this right, McGonigal, that he stole other clients' money in these different ways, and you could have said that happened here with the Johnsons, that happened here with HLADIK, but you don't. It's just this very conclusory assertion of conversion, but no information as to what exactly happened with your client's funds, and that's the problem here. Now, I'm not saying it may or may not be a sufficient basis for dismissal. I just don't understand why you can't fill in that gap with an amended complaint.
Could fill in the gap. We couldn't bring another case for two reasons. And the first one is that the facts in this case are very old. The second reason is that this case had already been to FINRA.
Could you speak a little bit louder and into the microphone? I'm having a hard time hearing you.
Sorry.
That's okay, yeah.
Gee, I'm often accused of being too loud.
No, you're not being too loud today, so keep going. One, the case was old, the facts were old, you said, and second?
Facts are old, and the case had already been to FINRA.
Yeah.
And as a result of that, FINRA has a rule that says that the statute of limitations is tolled while it's at FINRA. And so we had the benefit of a bootstrap, if you will, of part of the time to perfect our statute of limitations problem, which were glaring at us. And so because of that rule, we needed to keep this case. Now,
But why not just file a third amended complaint that fills in the gaps? You took an appeal instead.
He didn't allow us to do that.
Did you move to file? He dismissed it without prejudice. That means that you can move to file an amended complaint.
No, I don't think so. Not in the way that he wrote it up. He said this is to go to judgment right now. And so I don't think we had that option. Otherwise, I would have pursued it, of course.
Well, why did you dismiss it without prejudice then?
Because that's the rule. If it's dismissed because of a lack of standing, that's without prejudice.
So that you can refile.
then you could refile, except we had the problems that I mentioned to you. First off, it's really old.
But
and
Let's say
that-
the facts are old. Tell me what bearing that has on it.
Yeah.
Does that mean you couldn't,
Well,
you couldn't marshal the facts enough to point directly to McGonagall's conduct in your individual clients? I take it you're not one of the 15 who were in Fed court, right?
Well, I lost 2 years further on the statute of limitations because of the dismissal. I didn't get to get those 2 years back. And so
I'm missing that. 2 years because of the dismissal that's before us right now? What dismissal are you referring to?
yes.
The one that's before us right
The answer
now.
is yes. I lost that time to be able to argue that the statute of limitations hadn't run, and I didn't want to lose that time. So filing another case just set us back and made it so that it was even more difficult to defend the statute of limitations problem.
I don't see any barrier to moving to amend and file a third amended complaint, right? The judge gave you a green light to try that by dismissing this without prejudice. You were not foreclosed from doing that.
Sorry, but he didn't, because he said, this case is dismissed. He didn't give me the opportunity. I obviously would have filed another amended complaint. Now, it looks like we've sort of abused the system by filing 2 amended complaints, but the first one was just done because of misnomer of a name, and the second was because LPL said, well, you haven't made it clear enough in your complaint to spell out that LPL isn't liable to Mr. Hladik. We did that.
Right.
We did spell that out, but...
Sure, but the amendment is freely given in the rules,
Sure.
right? And yes, you don't have a right to file an amendment. You only get that one time, but you can go back and move to file a third amendment complaint. People file third, fourth amendment complaints all the time. So I guess I just don't understand why you decided to take this appeal as opposed to just giving another try and filling in the information that the judge identified as not being able to sort of conclude that there was a sufficient claim stated here.
Well, in our reading of the decision by Judge Salinger, we concluded that that wasn't going to be an option.
It says without prejudice in bold print under the order.
It does, and he invited us to file a new case, not to amend. He could have said, feel free to amend, and I would have done it in an instant. Since I then understood that he didn't accept that our plain statement of facts, and I think he conflated the difference between...
Is it fair to say that there were no additional facts that you could have relied upon or included?
Oh, no, not at all.
But did you point to those in the brief, whatever they are?
No, because they wouldn't be before you. They weren't part of the record, so...
So all the more so if you had those facts, and the judge says here, the facts alleged in the complaint are not sufficient to give plaintiffs standing to bring this lawsuit, you already were aware then of additional facts. Is that what you're saying to me?
I had been by then, yes.
I mean, you identified some additional facts at the hearing on the motion to dismiss. You said, well, there's this and this and this, and the judge said, oh, is that alleged? And you said, no, right? So
it's a function of when did I get that information. This case started out by lawyers in New York who brought arbitrations at FINRA, and FINRA said essentially 2 things. One, you don't have, as I understand it, enough evidence against in Mr. Hladik's case against LPL to proceed, and they dismissed his case as to LPL and its binding. As to the other claims, Mr. Hladik's case against SII and the Johnsons and Mr. King's case, they found that the 6-year eligibility rule at FINRA came into play. The events didn't happen within that time, and consequently, they can't go back.
Okay, but nobody cares about FINRA, or all we care about is this case,
Right.
and whether or not you can state plausible claims for relief in this case. And I guess the question is, and I'm just reading into what the judge did, is sort of, you can't tell from your complaint whether or not your clients lost, for example, $100,000 due to investing in a stock that went down, as opposed to the fact that Mr. McGonigal somehow took their money and put into a separate account, right? You don't have any idea of what the basis for the conversion is, other than you making this conclusory assertion of conversion. And so that seemed to be the judge's problem. Now, he framed that as a standing issue, and that may be problematic in itself, but it's just sort of, we don't know how the money was taken from your clients. There's no indication in the complaint about that.
I think there is.
What is it?
It's the difference between a fact and a conclusory statement.
No, what is the actual fact? What is it? How was the money taken from your clients?
That's not, at this point, that shouldn't be the issue.
Do you know the answer to that question?
The issue is that
There was a question.
Do we know the answer to that question?
you don't, I do now, the defendants do, they did then. And that's part of
And did you then, on February 26, 2024, when this case was dismissed without prejudice?
Yes. By then I did,
Okay.
yes. But the point is that the complaint is replete with comments about allegations that the McGonigals, as an agent of the two defendants, stole the money.
No, you say that multiple times.
I
right?
understand that, and that's the fact.
That is arguably a conclusory assertion, and setting aside the standing issue, under Rule 12b-6, you need to establish sufficient facts to establish a plausible claim, and it seems to be what the problem that the judge had here was, I actually don't know, I can't tell from your complaint, other than your conclusory assertions of conversion, what exactly happened, right? You don't have to have the full facts. We have to sort of say, one of the things that Mr. McGonigal did is he took this money and he put it into this other account. One of the things he did is he forged a signature, right? There's no information like that whatsoever. And so, you could read this complaint and say, here people are just trying to take advantage of this person being federally prosecuted, and because they had investment losses, right? You can't separate out that possibility from what you've alleged.
I understand that that's what the court determined at the time. But the trouble is that it's a simple case factually, and that's a fact that he stole the money from them.
Well, the fact is he stole money from some people and was prosecuted for it and was guilty.
These
That we
people
know.
among them.
Well,
But
that's not in the complaint.
Aside. That was the introduction to the complaint. Yes, he went to jail for it. He was arrested, convicted because he pled. But you don't need that to understand the case. That all applies to these people. He took their annuities, forged signatures. He lied. He said he was them.
He forged your client's signatures? Are you saying that?
Yes.
Okay, and he took their money, he took the money from their annuities and moved it into his own account?
Yes, and then spent it on his...
Where is that in the complaint?
It's not, but it shouldn't need to be, because all we have to do is spell out the fact that he stole the money. He used a variety of ways to do it from these 3 different or 4 different people. And
Did you know that at the time you filed the complaint? I just don't know why
I
you'd leave that
didn't
out.
have the detail at the time I originally filed the case, because we were in a rush to not lose the benefit of the continuity we got from the FINRA rule to make it so that we just got this filed.
Mm-hmm.
But it is a plain statement. It says that he stole the money, and we used a variety of words to describe stealing.
Using synonyms doesn't really get you
Yeah,
there, right?
it doesn't-
So
it
let me
doesn't
ask you
mean
this.
anything.
If we were to affirm on, say, a 12b-6 ground here, could you then go back and move to file a third amended complaint in this case?
Of course.
Okay.
And we
you'd
could
be able
spell
to,
out
you'd be
our
able to make
case.
allegations that address the issue that the judge identified?
I believe so, yes.
Okay.
I can't solve the statute of limitations issues, of course, but yes, I think we can. Of course we can. We could spell out our entire trial case at this point, if we had the opportunity.
Okay.
Thank you.
Any further questions?
I actually have a
further
few,
questions?
yeah,
I'm
I'm
sorry.
sorry.
A few
A
more
few more
questions.
questions.
So that my time was up.
So what is your response to the defendant's argument that your negligence claim is barred by the economic loss doctrine?
That was from LPL.
Because the doctrine says purely economic losses are unrecoverable in tort in the absence of personal injury or property damage. And you don't.
Well, there's a little more to it because they're a fiduciary.
Okay, but just for the negligence claims.
They're still a fiduciary, and if a fiduciary is negligent, I've got a negligence claim. And they are a fiduciary under PATSOS. Also, I think the Robin Hood case and the regulations from the Secretary of State all say brokers became fiduciaries.
Your argument is that the fiduciary aspect of this takes you out of the economic loss doctrine?
Yes.
Do you have a case that says that?
I can't recite it at this moment, but my understanding is that that's the law, yes.
Okay. And then your Uniform Securities Act claim, you're making a claim, I take it, under the civil liability provision of that act?
Yes.
Right.
It is not a good case. I acknowledge that the 110A case is not good.
Okay, because there's no allegation that any of the defendants offered or sold a security to your clients, right?
Well, that one they might pass, but the other characteristics of the statute we probably can't meet.
Okay.
So I'm willing to concede that, sure.
All right, thank you. That's all I have.
Anything else?
I don't believe so. Thank you very much.
Thank you.
Barely good morning, Your Honors. May it please the Court. Matt Bohenik on behalf of LPL Financial, LLC. The Superior Court correctly dismissed the second amended complaint because plaintiffs failed to allege facts supporting their standing to sue LPL and SII, rather than take a fourth opportunity to file a complaint that adequately pleaded standing. And even after obtaining documents and discovery, plaintiffs instead filed this appeal. Affirmance is warranted for at least three reasons. First, the second amended complaint fails to allege any redressable injury suffered by the plaintiffs. Second, the second amended complaint fails to allege any causal connection at all between any such injury.
You're citing the
LPL.
Article 3 standing requirements. We're not in Article 3 territory here, right? And so when you talk about injury, causation, redressability, those are all courts federal courts are limited subject matter jurisdiction. You have to satisfy standing in every case here. Massachusetts courts are different. Now, we've imported some of those standing requirements in particular contexts where there's a challenge to a separation of powers issue or a particular statute. It does not apply across the board where we have to separately plead standing requirements, particularly where there's just tort claims here. The whole standing thing seems very odd to me, and it seems like this is really a 12b6 issue, whether or not the plaintiffs have established sufficient claims for each of their four claims. Isn't that really what we're dealing with here?
Yes, Your Honor, thank you. So first of all, I think standing principles are applied in sort of the civil litigation context in Massachusetts courts. First of all, the Ginther versus Commissioner of Insurance case.
Versus Commissioner of Insurance,
Sure.
These a challenge to a state agency, right? Cite me a standing case where standing was separately analyzed, where there wasn't a separation of powers issue or, for example, a zoning dispute.
Absolutely. I have two Superior Court cases where we realize this arises. One is the Doe versus CVS case, and one is the Weld versus CVS case. In Doe, the plaintiff received protected health information of other CVS customers in that case, and she sued on behalf as a putative lead class member. And the court in that case found that she did not have standing to assert those claims because she did not allege that she suffered the injury, that her protected health information was shared. Similarly, in Weld involved a similar issue where
Also a class action case?
I'm sorry?
Was Well also a class action case?
They both were,
Okay,
yes.
that's different.
Yeah. And in Weld, actually, the court certified a partial class, but denied the class as to Weld because in that case, the protected health information had been shared with third-party drug manufacturers, and the Weld had not alleged facts that he or she had received the mailings that indicated that their protected health information had been shared.
So what is the jurisdictional standing requirement that applies to the plaintiff's conversion claim that is distinct from what they have to show to allege a conversion claim to begin with?
Well,
what is the difference between those two doctrines? Because I don't get it.
Well, so, I mean, standing runs to the jurisdiction to hear the claim for the court, the district court, the superior court. But I agree with you, Justice Toone, that the analysis collapses together. I don't think even under 12b-6 would the conversion claim survive, and I don't the other claims candidly would not survive either. Part of the deficiency in those substantive 12b in the 12b-6 claims that I think also apply to the 12b-1 claims is there's no claim of injury and there's no claim of causation between that LPL in particular did anything to cause the injuries complained of here.
Well, under a 12b-6 analysis, do we have to match up the allegations with each element of the claim, or do we make a holistic determination whether or not the allegations viewed collectively are sufficient to state a plausible claim for relief? Because here, we've already challenged your brother on what made the perceived deficiencies in the complaint. But here, I'm not sure that it's hard to say there isn't a plausible claim, right? McGonigal is this man who was federally indicted for investment advisor fraud. He's alleged to have worked as your client's agent, and they say that McGonigal stole their money, and they made these discrete losses. That's kind of a plausible. That's a plausible claim. May not be right. There may be defenses into that, but there's a plausibility to the fact that they lost money because your firm had hired someone who was stealing funds from their clients. So how do we get around that?
Sure. I have two reactions to that, Justice Toone. First is under 12b-6. The second amended complaint is insufficient to state a claim for conversion because in this instance there's no allegation that the conversion. So while money can be a subject of a conversion claim, it needs to be a particularized set of money. Like it has to be either coins, that are of particular significance, or it has to be a portion of money that was set aside for the benefit of somebody else. For example, if you ask somebody to hold money for you and they made off with it, here that's not the allegation. Here the allegation is that these funds were invested in the annuities, and then the funds were removed. What I will say is
that's not conversion. They're savings in annuities, and they get taken away by McGonigal. That's not conversion.
Under the law, I don't think this second amended complaint qualifies as conversion because, again, in a sense, the money is fungible. It's not a particular set of funds, which is what the case law requires. So here, I think under 12b-6, there may be a claim along the lines of what you're describing, but it's not a conversion claim under the governing law in Massachusetts.
I still don't understand that. Why people invest their savings with your company and it gets taken away from them?
Well, just on that point, Your Honor, and I think this is applicable to all of the counts and also the standing question. There's no factual allegation here that these plaintiffs were ever customers of my client, LPL. They do use the word customer, but that's a label and a conclusion. And other courts deciding the question of a customer have said a customer in the brokerage context either has to have an account, have opened an account, or purchased a security through a broker-dealer. Here, there's no allegation of any of those facts, and we actually, as a, you know, under
you don't think the conclusory allegation that the Johnsons were a customer of your firm, that there has to be more information to that? That seems to go way beyond, I think, what even Inachino requires, that level of detail. They have to itemize the exact nature of the relationship so we can make a legal judgment as to whether they really were customers.
But I think they have to allege that they had some relationship with LPL at all, and they don't allege that here. And actually,
It's not enough that they allege that Monocle did?
I'm sorry, can you repeat?
It's not sufficient that they allege that the investor advisor, Monocle, did?
It's not sufficient, Your Honor, because, and I see, may I
Yeah,
respond? It's not sufficient here because, you know, they haven't, another fact they haven't alleged is, you know, sort of when this alleged misappropriation happened. Did it happen while McGonigal was affiliated with SII? Did it happen when McGonigal was affiliated with LPL? And I'll note that in our 12B1 motion, we submitted affidavits showing that we didn't find any accounts, we didn't find any account statements for these plaintiffs. And I raise that just because—
How is that? And I'm going to ask your colleague about this too, because I do not understand how you can submit evidence. This wasn't a factual challenge to jurisdiction, this was a facial challenge, and you certainly cannot rely on affidavits and evidentiary materials in opposition to a 12B6 motion, and yet you all have done that repeatedly in this case. So I
And
find
it wasn't converted to a—
It wasn't converted, and it wasn't treated as a summary judgment motion. So it seems entirely improper to the extent that you all rely on everything in the supplemental record appendix, a complete violation of the rules. And so I just don't understand how you think that comes into this analysis.
May I briefly respond? So first of all, as I mentioned at the beginning, as I mentioned a minute ago, we don't think they allege facts to support plausible inference that they were a customer, number one. But number two, on a Rule 12B1 motion for standing, you are permitted to submit. The court is permitted to rely on evidence to decide a standing question. I believe this was in Ginther, although I can give you the—
And the nature of the relationship between the plaintiffs and the company you view as a standing requirement as opposed to a 12B6 issue?
Well, I think it's both, but I do think it—
Why is that a standing issue?
I think it goes to standing—
You need to establish a customer relationship to have standing?
You need to establish a causal relationship between the conduct at issue and the injury, and without a customer relationship, there's no causal chain between what all the allegations about McGonigal.
That's an element of the claim. That's an element of the cause of action. It's not a standing requirement that's separate from the cause of action. And you can't bring in evidentiary materials to challenge an element of a cause of action at the 12B stage. And the judge didn't treat this as a factual challenge to jurisdiction. So I don't know why we're even considering that now at this stage on appeal.
If you have a response, you may give it, and then we'll see if Justice Toone has any follow-up questions, or Justice Desmond.
I mean, again, our position is that the case laws there has to be a redressable injury caused by a defendant, and here without a customer relationship under the 12B1 standards here. Under the 12B6 standards, you're correct. Again, we don't think that the facts here are sufficient, but under 12B1, the affidavits can be considered in the 12B1 analysis. Thank you.
Thank you.
Thank you very much.
Thank you.
Did I hear you say, before you go, did I hear you say that the facts as alleged may have a claim, but it's not conversion?
I don't know what that claim might be, but it's certainly not conversion under the law, because the law requires a conversion of money claim to be, again, sort of like a particular antique set of coins, or money sort of held directly in trust for somebody else that was absconded with.
And so the pot of money and the annuity doesn't satisfy B, the second?
Correct.
Gotcha.
All right.
Thank you very much.
Thank you. Okay, so now you've had a preview.
I guess. I can also say good afternoon.
Yes, you can. Yes, good afternoon.
Members of the panel, may it please the court. Janine Lucas on behalf of SII Investments, Inc. I'm here with my local counsel. I'm from Michigan. My local counsel, Kirsten Patzer, is here with me as well. Thank you for your time this morning. I'm not going to spend a lot of time on the standing issue. SII did not move to dismiss under the standing requirement. That said, I think the court's decision in that regard was correct, but I'm going to spend more of my time on the 12b-6. Before I get to that, I do want to clarify or correct a few statements that were made on behalf of the plaintiff, the appellants in this case. And that has to do a little bit, it relates to the statute of limitations, which is something I want to talk about. And it's true that the statute, while you have a pending FINRA arbitration claim, the statute of limitations per the FINRA rules is told. In this case, however, only one of the 4 plaintiffs filed a FINRA arbitration claim. Mr. Johnson, Mrs. Tard Johnson, and Mr. King never were parties to any FINRA arbitration, and nothing was told as to them. With respect to Mr. HLADIK, who did file an arbitration claim, the statute of limitations is only told for the period of time that FINRA has jurisdiction over the claim. And the claim against, there were 2 defendants, SII and LPL. The claim against SII was dismissed after several months. I believe it was 5 months, I can't recall off the top of my head, but the statute of limitations is only told for that period where Mr. HLADIK's claim against SII was pending. One argument or one fact, one aspect of the complaint that I think is deficient, which underscores SII's, the majority of its arguments, is that this case was brought by 4 unrelated plaintiffs against 2 unrelated. We could have 8 lawsuits here. The plaintiffs simply banded together for a matter of convenience, and I appreciate the court rules allow certain claims to be joined. We didn't dispute that. But the fact is that there are 4 individual people with individual claims. This is not a case where they're saying we're all a joint account holders of the same account, and therefore we're claiming claims as to the same pot of money. The same goes for the defendants. We are distinct legal entities. In 2018, it's true that LPL purchased the assets of SII, certain assets of SII, not all of the assets, and not the liabilities, and that SII maintained its own independent legal status. It wasn't a merger, it wasn't an acquisition. So in other words, no party in this case stands in the shoes of another. The defendants are not liable for each other's conduct, and that's important here because it means that each plaintiff has to assert allegations to support a claim against each defendant. You can't just lump everything together and say McGonigal stole money. What money? And when did he steal it? And when is significant here because, as plaintiffs admit in their complaint, Mr. McGonigal, who I will point out is not a party to this case, he was associated with the defendants at separate, distinct times. Plaintiffs admit in their complaint. Any relationship between McGonigal and SII, and therefore plaintiffs, ended in February of 2018. Anything that happened after that, SII couldn't possibly be responsible for. It wasn't even in business anymore.
So just to cut to the chase, your argument is that the complaint is deficient because it doesn't specify when the various acts of conversion occurred and therefore can't tell which of the 2 corporate entities is liable as having McGonigal acted as their agent?
That's certainly part of our argument. That's not all of our argument. And I do appreciate appellant's argument that this is a notice pleading, not a fact pleading jurisdiction, and that all that's, excuse me, all that's required is a plain statement to put the defendants on notice, but when you have a group of plaintiffs making group allegations against two different entities, that doesn't put the defendants on notice. My client is not on notice, based on the allegations in the complaint, of what is being alleged against it versus LPL. How do I defend against that? How does SII defend against? So I think in this case, the when is an important fact that's missing.
I'm sure the when is helpful. It's helpful for you to muster your defenses. I mean, you'll find out soon enough if this case goes to discovery, right? You'll find out exactly what the alleged acts of conversion are, when they occurred, and then you'll have defenses depending on whether or not your client was responsible at that time, right? So I don't know whether Rule 8 requires that every specific act be kind of dated for that purpose, even though it would certainly be helpful to your client.
I believe that because of the fact that we have multiple parties, like if it was a single plaintiff and a single defendant, we wouldn't have that issue. But that's not the case here, and there's a break in the chain. These are not time. McGonigal was not, his time with the two different firms didn't overlap. And I think that basic fact needs to be in the complaint to survive a 6B motion. And I see that I'm running out of time, and so I will say that I don't think that conversion was sufficiently pled. Conversion is taking somebody's personal property, and no property of the plaintiffs of each plaintiff is identified anywhere in the complaint. There's just general references to accounts and annuities, but whose accounts and whose annuities? And when was it converted? Was it while McGonigal was acting in the scope of his authority with SII or LPL? Breach of fiduciary duty, I disagree with appellant's counsel. Mr. McGonigal was a stockbroker. He was not an investment advisor.
Well, he's alleged to be an investment advisor.
He's alleged to be an investment advisor.
So doesn't that resolve the question at this stage?
I don't believe so, because whether someone is an investment advisor or a stockbroker is a public record. And I do believe that is one document that the court can consider on a 6B motion.
A public record as to the status of a person, whether or not they're an investment advisor or a broker, that's something that we should go outside the pleadings and make a determination on, where it's contested by the plaintiffs?
I do think that the court there are limited documents that a court can consider, documents that are referenced in the complaint, court orders, statutes, things like that, and matters
That's not
of
referenced in the
public
complaint.
record.
Right. I mean,
that's not referenced in the complaint. His status, in terms of his document that would show his, a public document that would show his status at a particular time.
It's not, that document is not referenced in the complaint, but it is a public document that I believe.
But the judge is not going to go out and research this. This is not, it has to be part of the pleadings at a minimum, even if it could be considered.
I think it's implicit in the complaint in that they identify Mr. McGonigal by something called a CRD number in the complaint. That is somebody's broker check number. And broker check is the document I'm talking about, and it tells an investor, is someone a stockbroker or an investment advisor?
Okay.
Can I just, you were making a 12B6 motion, and your brief to us is suffused with references to the supplemental record appendix, which consists of affidavits, evidentiary materials. None of that is appropriate for a 12B6 analysis. Don't you agree with that?
I agree with you. I don't agree that none of it is. I believe that some of the, and one of them being the broker check report, I believe there are limited documents outside the four corners of the complaint that can be considered. Notwithstanding, the four corners of the complaint, I think, are deficient in that they don't sufficiently allege the elements of any claim. And I know I'm out of time. I do want to, the statute of limitations.
That's going to be it unless we have further questions. Thank you very much.
Thank you.
All right, we'll take the case under advisement. The final case for today is case number 2025-0009, BRAHMIN Realty Associates versus Colonial Trading Company.
Good afternoon. John Harkavy, representing the appellant, Colonial Trading. We want to try to discuss 4 issues, if I have enough time. Whether there was a material breach by the landlord prior to Colonial's default, whether the landlord waived its right to enforce regarding a subtenant without written permission, whether the trial judge erred by not treating affirmative defenses of waiver, offset, breach of covenant of good faith as a counterclaim, and whether damages were calculated incorrectly. Just a few essential facts. The lease was dated September 22nd, 2017 for 5 floors at 44 Bromfield Street, and initially the landlord and Colonial had discussed renting floors 1 through 2. There was always a subtenant. Initially, there was a subtenant called Bosworth Place that sublet floors 3 through 5 for at least a year.
Did Colonial have any obligation to the landlord with respect to the subtenants? Did Colonial have any obligation to the landlord with respect to the subtenants? Any obligation at all?
They have to abide by their lease.
Colonial
does.
They have to provide any documents relative to the subtenant to the landlord.
I think they waived. That's my argument with regard to waiver.
My first question is, did they have to do it?
They didn't have to do it once the landlord accepts the rent without complaint. And they accepted the rent from Colonial for a year with regard to Bosworth.
Does the lease say that Colonial has an obligation to provide any document to the landlord if they have a subtenant?
They have an obligation that can be waived.
What was the obligation?
The obligation would be to have them present certain materials and the landlord in writing.
Did they do that?
They did not do that.
Okay. Go ahead.
And Hostel came in and later on, and once again, the landlord accepted the rent from Colonial.
Isn't there language in the lease? I mean, this is clearly a landlord's lease. Isn't there language in the lease that says whatever challenges you bring, whatever infirmities you may allege, you still got to pay full rent?
There is language in there. However, their anti-waiver languages and leases has been disregarded by courts. That's not the end of the issue. When a landlord accepts the money, that is a waiver of that, can be of that particular clause.
So so I get that. So do you agree that there was a breach by not providing the required documentation to the landlord? That the breach first occurred, whether they accepted payment or not, that the breach first occurred by Colonial?
That was never raised by the landlord.
Do you agree with that?
I don't think that was a breach necessarily, because it's not a breach when the landlord accepts the rent and doesn't say that we're going to not accept your rent and give you notice to cure a breach. So
if it's not a breach, how are they going to give you notice to cure it? So are we saying the same thing?
The landlord could have said at the very beginning, hey, you have a subtenant in there. We think that's a breach. You have time to cure it, and give us the documents and we consider it. But they didn't do that.
And you think that's their obligation to do that?
Yes.
Okay.
And so under the case law, where the landlord, I think it was a material part of this lease that my client, Colonial, was going to be subletting. because in fact, in section 17 of the lease, they specifically talked about subletting and what could and could not be there. And that was a material inducement for my client to enter into the lease, that they were going to be allowed to sublet. And they had it's unequivocal that the landlord knew about both subtenants. At some point in time, they said, hey, you have a subtenant, we never approved that. But at that point, it was a material inducement, and it was an important part of the lease for my client, and that's, I say, is a material breach by the landlord. And at that point, my client has certain rights and offsets. Even though the lease says...
No offsets.
No offsets. That's, again, those are the term, my client could have walked from that lease and would not have been responsible for the rent. If they had left, I would say it was a constructive eviction. Now, did they leave? No. Why not? Because my client had already put down $200,000 in renovations. And the landlord knew about the renovations, and they were satisfied. In the record, the testimony was that 5 people from the landlord had inspected, said it was fine.
Did Colonial have an obligation to provide any documents with respect to the renovations to the landlord?
Yes, they did.
Did they do that?
They did provide certain documents. What they did not provide was the sign-off from the contractor.
Which is contained in the lease, right? Which is a requirement in the lease.
Yes, but once again, my point was, once the landlord
accepts the rent. Once
the landlord says you can't have a subtenant that you know about, which is a material part of the lease, and the inducement to enter into the lease, my client's obligations end. So they didn't have to follow all the ABCs of the lease, and the courts have found when there's a certain, immaterial case where they didn't abide by the entire lease, but the gist of it, he did the work, the landlord knew about the work and accepted the work, and only when my client says, hey, you owe me the $26,250, they said, well, you didn't give us the contractor sign-off, and my client says, well, the reason I couldn't get a sign-off was because the landlord itself had hired that contractor. So we weren't able to fit through A, B, C, and D, but we did give them A, B, and C.
Hold on. How is it that the landlord had hired the contractor themselves?
Yes.
And so therefore, did your client pay the money?
My client paid the money.
To who?
My client had paid the contractor, if that's what you're referring to.
It is?
Yes.
But the landlord hired the contractor.
Correct. But the contractor, it's my understanding, did not respond to my client's request for the sign-off, and that was an issue. That's the one issue that my client could not provide.
And did the contractor provide your client with some reason that they wouldn't sign off?
I don't believe there's anything in the record with regard to that. But I think my client testified that he couldn't get it because he was hired by the landlord to do other work on other buildings. And I point out with regard to the waiver issue, the Bacors versus Miller Forceland case, and the receipt of rent after a breach of may be inferred from a party's conduct, where the conduct lease is a waiver of the breach if received with knowledge. And that case, also the Tage 2 Corp. Versus Dukas Realty Corp. It's undisputed that for these 18 months, my client was paying, and the landlord knew about it, and they also had subtenants in there. So my response is that they waived the right to enforce that particular portion of the lease.
You're talking about batch horse, is that the case?
Excuse me?
Batch horse versus Miller's?
Yeah, the batch horse versus Miller-Forstland, 812 F sub 2nd 83.
Right, so that's a case where the landlord continued to accept the plaintiff's rent payments despite knowledge of the violations. But here, the landlord did raise these failures with hostile, correct?
Only after 6 months.
Only after 6 months, okay.
So what I'm saying is when the first subtenant was there and they accepted rent, that waived that particular portion of the lease that says you have to give us A, B, C, and D in written permission. So that...
For all future,
right.
For all future subtenants.
Right. And
that seems a different principle from what the First Circuit held in that case. They said, well, up to that point, right, if there's no complaint then in accepting the rent, but you're saying, well, that fundamentally changed the terms of the lease going forward for future subtenants, which seems to be another proposition.
Well, right? Even with the second, with hostile,
yeah.
They knew about hostile for 6 months before they said you have to get rid of hostile. And as I point out, that...
So what? So therefore what? So even if they did know about hostile before they acted, what does that mean to us?
To this court, it should be another waiver. So they waived it. They waived the right to insist upon
Is that in the lease?
Exact performance.
Is that in the lease?
That's under the case law, Your Honor. That if you accept rent, and if the landlord accepts rent without, any reservation of rights, which is what they did, there was no reservation of rights. They didn't say, all right, Colonial, we're going to accept it this month, but you have to get rid of these guys or, provide us the documents that we want under the lease. They didn't do it. They just accepted it. And at some point, they said, no more. You get rid of hostile.
Just reading the judge's decision, tenant did not provide the required paperwork regarding the sublease to landlord. Accordingly, landlord sent a letter to tenant to terminate the sublease. That's what the judge found. And so you're saying there was too much time between those two incidents and therefore it amounted to a waiver?
Yes.
Okay.
That is my point, that there's an affirmative defense of waiver, and the trial counsel raised that in his pleadings and also in his arguments saying, hey, he did raise it's a material inducement to have the subtenant and you shouldn't.
It seemed to be a lot of factual premises to your argument that the judge didn't agree with, so we have to sort of kind of find that the judge made clearly erroneous findings as to each element of those.
I think what the judge did, and it's hard because he only ruled on one sort of aspect of the no counterclaim.
Yeah.
And I think trial counsel for the landlord raised that issue vociferously in the case, saying, hey, there's no counterclaim. So you can't accept any of the defenses of set-off, waiver, et cetera. And in the judge's ruling, he only specifically referenced the breach of the covenant of good faith, I think, said there was no counterclaim. And my position is that under Rule 8C, if it walks like a duck and it has feathers, it is a duck. In other words, if counsel raised certain defenses, which also could have been a counterclaim, the judge and the court, when justice requires, can consider it. So I think the judge erred by his conclusion that I can't consider certain defenses because a counterclaim wasn't raised. I'm saying is from the very beginning of this case, trial counsel said, my client has certain defenses such as set-off and waiver, and
I thought that the judge's ruling on you not asserting a counterclaim involved your claim that the landlord tortuously or intentionally interfered with the tenant's contract with Hostel, the prospective subtenant, right?
Right.
But the judge didn't make that point with respect to the offset. The judge just addressed that on the merits, said the lease specifically bars tenant from seeking an offset against the amounts owed to landlord and requires tenants to pay all amounts owed without any set-off or deduction whatsoever. So you're trying to say, well, the judge erred in sort of the procedural issue, but he just addressed that issue kind of head on. The counterclaim issue involved a different issue. Am I mistaken there?
I think it's all intertwined. So, once again, I don't think trial counsel brought all the issues he could have in the best light, but based upon what the record is that the judge did not consider all the claims because they were done as affirmative defenses, and trial counsel said, I don't have to because it offsets the damages the landlord has. And there's no doubt that with regard to damages, that my client stopped paying during COVID and for a year or two afterwards. There's no doubt about that. And
you need to sum up if there's no further questions. No further questions. All right. So you
I
actually.
have another question.
You do? Okay, one more question, yeah, because your time is up. Justice Desmond?
So my understanding was your position is that as a result of receiving the default notice from the landlord, Colonial kicked the hostel out. Is that right?
As a result of, no, it's as a result of receiving an email from the landlord saying you have to get rid of them.
Do we have the email?
Yes, that's in the record.
With no further questions, you're going to have to rely on your brief.
Okay, thank you.
Good afternoon. Jack Siegel. The 11 exhibits, 2 witnesses, this is a very straightforward case. The lease is very clear. Basically what the judge heard from the defense was that, the court should use its equitable powers and it should consider fairness. And here we were unfairly treated by our landlord. We did expend money and we should get some credit for that. We did find somebody that we thought was an acceptable tenant. That should have been good enough for you. But that's not what the lease provides. The lease provides very specific things that need to be met. And counsel admitted on the record that, this is trial counsel for the defendants, that they did not meet the requirements of the lease. They did not submit the required paperwork. They did not pay the rent. The lease could not be more clear in terms of what happens in the event of waiver. There is no waiver. The case that was discussed, I'm going to pronounce the case wrong, but it's the Becor's case. In that particular case, there was no ultimate waiver as to a lease provision in perpetuity. There was a limited waiver because there was awareness of the sublease, accepted monthly payments, and even something more than that, action taken by the landlord itself to facilitate the sublease's occupancy of the premises. So the facts of that case are particularly strong. Here, in response to a letter from us telling us they need to have their proposed subtenant vacate, they kicked the subtenant out. They didn't do anything that's inconsistent with recognizing the terms of the lease and that they didn't comply with the terms of the lease. All the actions they took were consistent with the terms of the lease. We followed the terms of the lease. So the judge was made aware extensively about all of the arguments that were made. What I thought was interesting, though, is the material breach argument. you would expect that that would be something that they would have pled as an affirmative defense. They did not plead that as affirmative defense. That's not one of their affirmative defenses. Waiver is an affirmative defense. They alleged, and we're not talking about force majeure and frustration of purpose because of COVID, but there was never an allegation that we materially breached the lease. The only evidence of breach in this case is that they breached the lease, that they're not even denying that they breached the lease. So unless the court has particular questions, I think the judge's opinion, and there is no challenge to the facts. There was no attempt in the brief or here, even on oral argument, to dispute the facts as found by the court. They were accepted.
Does section 17.3, is that applicable in this?
May I grab the lease?
Sure.
Thank you.
Or does 17.8 say that 17.3 is of no moment here?
Yes, 17.3 is the proper procedure for effectuating a proposed subtenancy.
Right, but doesn't 17.8 say, for the avoidance of any doubt, such subleases shall not be subject to the provisions of section 17.3?
Just one second, Your Honor, I'm sorry.
Take your time.
Yes, it does say that.
So is 17.3 in play or not?
17.3 is in play, yes.
Is?
Yes.
Notwithstanding the language of 17.8?
No, because permitted uses would mean like a lawful occupancy. And what was discussed at trial was that it was our view that the hostel, which was operating as an Airbnb, didn't have the appropriate certificates of occupancy or the appropriate, we had seen no evidence that they had appropriate right legally to operate as a hostel. So it's not a permitted use under the lease. Because under the lease, we're at no point are we saying it's okay for you to conduct illegal activities on the premises. So that was a bone of contention. I think what the testimony from Mr. Chorney was, is I did the best I could with, at the time, you know, essentially in a trial, they had the opportunity to call witnesses to come in and particularly from this hostel and to come in and talk about the uses and they didn't do any of that. This, the affirmative defense of waiver and their rights is really on them. And the judge didn't have any of that before them, but our position, what we articulate as the basis for saying the hostel had to go was because we thought it was illegal, because we only found out about it from an Airbnb advertisement, and then we were like, you can't run an Airbnb in this building without appropriate government approval.
And how did you communicate that? Did you communicate that by sending them a default notice, or was it just an email?
It was
in the brief for Colonial on page 12. It says, as a result of receiving a default notice from the landlord, Colonial demanded that the hostel leave. It doesn't say as a result of reading an email. So was that the email he was referring to?
Well, there's actually a September 3rd, 2019 that talks about, this is Exhibit 6 at the trial, which is a notice to quit. References here made by a default notice, I'm sorry, a notice of default, and it specifically talks about the occupancy. So this is almost immediately upon being sent, and from a chronological standpoint, we get sent a sublease in September of 2019. In September of 2019, we send a letter that says it's illegal. And they continue to stay there. We don't resort to self-help and throw the hostel out. We just continue to have discussions with Mr. Chorney and Colonial, right? What are we going to do about this? And then finally, somebody from our offices sends an email that says they've got to go.
And so when you sent the email saying it's illegal, was that a default notice?
No, the default notice was the original September 3rd, 2019 notice. That's Exhibit 6 at trial. So the way the chronology worked is they let the tenant in there. They then sent us a copy but didn't follow like any of the provisions of the lease that we think needed to be followed. Whether they needed to follow them or not, we determined that the lease use was illegal. We sent them a notice of default because having illegal use is also a default of the lease, right? And this follows up on other default notices that we sent thereafter regarding failure to pay, but this was one of the first default notices that we sent to them. And this was essentially, they're talking about a delay or a lag in time. It was the same month, if not the same day that we received the lease, right? So we put them on notice, and then it took some time for them to act on it. And then we finally had to say that they need to go. And so we sent a letter saying, go. And I mean, the judge heard this. And the judge, when they say, well, the judge didn't consider, and the judge didn't, we don't know what the judge specifically considered. We can't assume the judge didn't consider what was said in front of him by counsel and the witnesses. I think the assumption would be he did. And he found specific facts, none of which they have contested are clearly erroneous. And his conclusions of law follow from those facts, applying black letter case law. So it's a straightforward case, and the court should affirm it.
Thank you.
Looks like there's no further questions from the bench.
Thank you.
Thank you. Thank you both very much. That will conclude all of our arguments that we hear today. Thank you, everyone in the courtroom, for your assistance. Court will stand in recess.